posted to 41st February for adducing evidence on behalf of the accused. On that date, he was under training. On that particular date, for which an adjournment petition was filed, that was rejected, and the case is posted for argument by closing the defense evidence. But the 3rd of this month, Lordship kindly allow to tomorrow take up the matter.
Tomorrow not possible.
A day after tomorrow, because 3rd of this.
No,
Third-
you can ask for adjournment. What is the big deal about it?
But he is posted for adjournment petition has been rejected once.
What is your petition?
My lord,
What is you are paying here?
my lord, praying to stay the further proceeding as well the quash the order of the London Trial Court, who has rejected my petition, and he has not given any opportunity to adduce evidence on his behalf.
For
Petition is the accused in the trial court.
defense evidence.
Yes, defense. That was rejected without a beginning option. Even if the petitioner was on training on that particular date, I have filed the document before your lordship. On that date, the petitioner was on training.
What about 313 statements? Have you said that I lead evidence?
But accused statement has been recorded.
But at the end, have you said that I will lead my defense evidence?
But that was rejected, my lord. Petition adjournment.
No, that would be the obvious question at the end of the 313, whether you lead the defense evidence or not. If you say no,
No,
there
my
are
lord, I will. That's why I filed. That's why I filed by stating specific that I will adduce evidence.
नहीं देखो.
May I take leave of your lordship to mention, my lord?
Yes,
Item number 121. That is connected to CRLMC 3874 of 2022. Well, this is Macmillan Education India petitions are the directors. The matter in the meantime, both are connected to each other. On a private complaint, FIR has been lost, registered. So both the matters have been in the meantime compromised. So laws will come from Delhi. Already compromised petitions are filed. So may I pray, my lord, may be pleased to direct the matter to come up on 3rd of May. And kindly.
if they will appear in VC, I will do it today itself.
No. This may come up.
This is a revision of what? CRLMC.
CRM. This matter is connected to the other matter also. Both are same
Both the matters.
and arise out of the.
Since you have settled the dispute, on 3rd I have no problem. 3rd I will take it up, but bring them so that we will finish it up. But the parties have to be here.
Both the compromise petition filed, both parties will be there. That will be simply disposed of. But I only humbly pray that since a lawyer will come from Delhi, may be taken up on 3rd at 2 o'clock.
3rd, 2 o'clock, I don't know. 3rd, there is some dicey situation.
3rd may not reach because serially it may come 120, 21 like that. So
3rd and the 10 o'clock.
Pardon? 10.
3rd, 10 o'clock.
Obliged. Much obliged. My both the matters to come.
Exact 10 o'clock.
Much obliged. I am deeply obliged. I am
program. I may not, hold the court after 11 o'clock because
I am deeply
maybe traveling. I don't know.
I am deeply.
That's the reason.
I beg pardon, my lord. Item 1838,
Seriously, one.
1838, 88 after lunch. Because
After lunch, I'll take.
हाँ हजूर से आम कहीदे नगले कहीं भिजिलांस केस अपियरेंस अच्छी 10 रू 2टा
हाँ को आइटम
आइटम 18
18 पासवर्ड कर दिया
38 88 2टा वाला
30 18 38 and 88
88
तीनटा
my lord
और तीनटा ये लंच पर है
44 because he will appear before
okay relax you go
item
44 your lordship and 18 38 and 88 तीनटा after lunch.
Item 44 Millard, any date next week. Press admission message.
Sorry, I couldn't.
Item 44 Millard, I pray for next week, any date.
Next week, I'm not sure, but adjournment is sure.
Lordship, I mean, partnership, which is face matter, lordship.
Lordship,
Face matter, Krishna is a government employee, is a conviction period of 2 years, lordship, and a fine. Next week, end date, lordship.
Press matter.
Face matter, vigilance. 2 years conviction.
2 years. And the time is granted up till?
On 4th it was fixed.
Take it up tomorrow.
My lord.
item number
Suspend the sentence
Proceed.
and admit the appeal. What?
Proceed.
2 minutes.
Proceed. Bless.
item 9 minutes
CRLMC matter. This is compromise matter. Like this matter. It has been compromised matter.
Compromise matter, you give it, we'll take it up.
Pardon, my lord. A second. Press admission 482 application filed. Proclamation notice has been issued in favor of the present
If
petition.
you don't go, then proclamation will be issued.
That is why, my lord, I pray.
Cancellation of NBW.
Yes, my lord. That is-
Cancellation of NBW. Cancellation of NBW.
My lord, of item 102, my lord. I pray
Next
for
week.
adjournment.
102 adjourned.
102.
Press matter? Fresh matter?
No, no, my lord, matter has been compromised. And personal appearance fine thela se 80%.
Order to cancel, my lord.
Item 9, my lord. Item 9. Matter is fixed for my lord, appearance of the both the parties, my lord. Since the parties are staying at Delhi and Bombay, my lord, they are unable to come today. Because, my lord,
I said,
Well,
let
there
them
are-
appear, we see.
there are 4 petitioners, my lord. They are staying separately. And they also leave the my lord, company and join the other company, my lord. So take it about 2 weeks after, then we come.
They have separate mobiles.
Yes, yes.
They
my
can appear in their own
lord. Then-
mobiles.
The lawyer also not unable to come and
Can
contact.
we adjourn?
Yes, my lord.
Order to cancel, my lord. CRLMC 2 of 2023. Offense under section 311 of CRPC, my lord. This case was specific as on to 18 May 2023.
Give it.
But still it has.
Beg your pardon, Lord.
My lord, tomorrow, my lord.
Don't say all these things tomorrow. 133 matters listed.
My lord, my lord.
How can you expect that tomorrow your matter will be taken up? Let us see, we'll see. What else could be done, we'll see.
My lord.
We'll do.
Beg your pardon, Lordship. Item number 4, Lordship. On behalf of Mr. Chan,
Four.
kind Lordship.
4 will come within 4 minutes. Wait,
Lordship, praying for adjournment, Lord.
wait, it will come.
May,
Are you
may I
going?
please to mention, my lord?
Wait
I'm
for
back.
two- And yes,
Pardon, my lord, Belgium matter.
Belgium, please.
My lord, item 90 and 120 of today's weekly list. Kindly, therefore, I'm
When
praying
the
for.
matters are listed, you are asking for adjournment and you want that other matters should be taken up. Right? What is this?
90 and 128.
Why?
Therefore,
Why? But the matters which are listed, you won't do.
therefore, one with
And
my
the
lord.
other matters has to be listed.
Therefore, one with my lord.
Item 90 requisites will be filed. But
Requisites have the entry model is there.
My lord.
Wait, I may vacate it out.
My lord. My lord, why not?
Either vacate because you have not filed requisite after taking entry model, or cost will be imposed. Be ready with it.
My lord, therefore,
Once
one with my lord.
no, the once interim order is granted to you, you don't file requisite, then the consequence is either it is vacated or pay heavy cost. Wait, we'll see.
My lord.
Yes,
Item 73 permitted to withdraw, my lord.
withdraw. Yes. Any,
Item
I'm at a BC, my lord.
1 minute,
I'm at a BC.
One-
I'm at a BC.
1 minute. I'll just.
Lordship, item number 116 on behalf of Senior Counsel Mr. Subir Palit. He's on accommodation this
It's
matter.
all right, but is there an entry model? Where is the who is appearing for the other side? Huh?
State.
State. Entry model is there. Entry model is there or not?
No, sir. I'm not.
Yes or no?
No, sir.
Entry model is there or no?
No, sir.
Sure.
It's there.
I was in.
Let it come. Tick mark rakho.
Pardon to mention, my lord. Item number 114. The conducting counsel's father expired.
114 agent.
My lord, may
Well, I'm at a BC, my lord.
Why I'm saying, my lord? It
I'm-
is the 10th day I am understanding. His father's 10th day.
Yes.
That's right, but our board has to also permit. We'll see. We'll
pardon to
get
make a
here.
mention, your lordship.
We'll
Why I'm
take.
saying I'm suffering all, I don't object to the bail, my lord.
You never suffer. You make others suffer.
But see, you should have informed me.
Yes, I've informed.
No,
I've informed his
you
associate.
should have informed earlier because.
Earlier, my lord.
Maybe a week after you-
Today morning, my lord, I have informed.
We'll see.
With your kind permission, my lordship, item number 83. There are some SR defects, so please adjourn the matter and
83. You will cure the defects. Okay. 83 will cure the defects.
Pardon to
Well,
make
I'm
a
at a BC.
one
I'm at
compromise
a
matter,
BC, my lord.
my lord, one compromise matter, your lordship. Another one is, my lord, one fresh admission, what is happening in this case, your lordship.
One matter, one day.
My lord, may
All mentioning you don't do.
permit.
I'm at a BC, my lord.
The petitioner already granted anticipatory bail in this case, your lordship. But the charge sheet is submitted in 307, your lordship. So the court, Learned Court below taking cognizance in the 307. So I may be permitted.
You give the memo. We'll see.
No.
Yes. Any mention?
No, I'm at a BC, my lord. I'm at a BC. Item number 11.
Yes, yes,
Item-
yes. Mahapatra.
Item number 11 and 67 taken up after vacation, my lord, because I have some problem.
11 and is there any entry model?
No, my lord. No, my lord.
Item 6 and 67.
Item 11 and 67. Item 11.
Adjournment.
67.
May I please to mention, my lord?
Yes.
Lordship, item number 10. It may be
Yeah.
taken after lunch, my lord.
Item 10 pass over. Yeah, okay. Okay.
Okay, lordship, I'm mentioning it here.
One more, wait. Yes. Yes, yes. Yes, Mr. Das. Okay.
131 and 131, 132 and 133. The three matters are arising out of confiscation proceeding against the authorized officer. Interim order
Section 17.
7, Section 17 of the Dismissal Act. That has been already decided by the coordinator.
Decided means you are covered by.
Yes.
We will do it today.
That's it.
We'll do it today if you are covered.
What is the
Lord, I am
decision
I'm
presence of the
OPID.
vigilance.
Let them come. Let them come. Yes.
In item 114, there is an interim order. Kindly extend that.
Entry order.
Pardon me, my lords.
Pardon my lords. Let us start the matters now.
Pardon me, my lords.
Give the memo.
My lord, item number 95.
Taken up first, my lords.
Item number 95. In the requisite should be filed in the meantime, your lordship. Though not requisite, not filed.
Interim order is there.
What is there?
Is there any interim order?
Yes, your lordship.
Wait. It will be vacated.
So what happened is we are not able to find the address of the petition also.
But whatever address you have given, you should have filed requisites.
My lord, we are now we have the
Now
correct
you
address.
have, then you pay some cost. Let us see. Once you take interim order, this risk is always there.
My lord.
So no question of not filing requisites and all. Cost.
Lordship,
Yes.
Lordship, am I audible now? Lordship,
Yes,
am I
Mr.
audible?
Khan.
Lordship, I am mentioning a press matter that is CRL MC 1445 of 2024. And then petitions are serious.
I am not able to follow either you travel in your car or
of FIR and other
or come down to some place and mention. Both the things can't be done together.
I'll mention those.
Traveling in the car.
Lordship.
Obviously, that's the reason there is a
I'm just held up with the
problem.
phone, my lord. I'm held up in traffic. Lordship.
Nothing. Can't be. What is this?
Not to be allowed one this time.
It shouldn't be allowed. At least let them have little courtesy towards the court. Not traveling and and they should stand somewhere and do something.
This is also disrespect to the court.
Disrespect to the the system itself.
System.
Liberty is given to do in online doesn't mean that you traveling in the car and
For that, my lord, the fine cost have been imposed by could not bench. Cost have been imposed because of that.
natural. Some cost, a token cost required. Or you have an extreme urgent situation, at least you tell that I'm sorry I'm appearing or something. Then one can understand. Not that take it as a granted and do it. Yes.
Item 2.
Yes.
May I please, your lordship. In this case, I filed for quashing of the order of the cognizance dated 8/10/2021, my lord.
Yes.
But in the meanwhile, all the witnesses have been examined except the official witnesses. So my limited prayer is to expedite the trial, my lord.
How many witnesses are there?
Total, my lord, 11 witnesses.
All witnesses are examined.
Yes, my lord. Only the official witnesses, three of the official witnesses have not been examined, my lord.
Hang on. The petitioner has challenged the order dated 8/10/2021, whereby the learned JMFC bracket P Pujongo in GR case number 840 of 2021 have taken the cognizance
Yes, my lord.
Taking the cognizance.
At page number 18, my lord. Cognizance order, my.
Against the petitioner. Next one. Learned counsel of the petitioner submits that the trial is at advanced stage. Therefore, he doesn't want to press this petition. However, he prays that the trial may be expedited. FIR ke bolo?
FIR, my lord.
21.
13/8/2021, my lord.
Further submits that how many witnesses are examined?
My lord, I have exiled only the today I got from my lord. Only the official witnesses have been, my lord, have been not.
You don't know, then how can I expedite?
My lord, total 11 witnesses are.
Simply say expedite. That's
For this means that the trial may be expedited. Trial may be expedited. Unless counsel of petitioner is given liberty to make the same prayer before the court below. With this liberty, this petition is disposed of. Yes.
The time stipulated.
Yes. Next.
Oblige me.
When you are making some statement, you should be very careful.
Yes, ma'am.
You should have told how many witnesses are there, how many examined, how much time. Don't make blank prayer. Okay. Next.
Item
okay.
3.
3.
Item 3. Can I pray for an adjournment?
Adjourn. Adjourn. August. Yes.
Item 4.
Lordship, item number 4, Lordship. On behalf of Mr. Chand, Lordship, kindly taken up next week, Lordship.
Don't say next week. What is this matter is about?
Lordship, once you see complaint case, Lordship.
Cognizance order.
Lordship.
You have not filed anything except a file. Right on. The petitioner is challenging the order dated 24/5/2022, passed in GR case number 132 of 21 by learned JMFC Hindilikat, whereby the cognizance for offences, which offences? Order also you have not filed. Cognizance order also you have not filed.
Lordship,
Cognizance of offences has been taken. Neither the copy of charge sheet nor the order impugned in the petition filed. Therefore, the present petition is dismissed with the liberty to the
Lordship, kindly
liberty to the petitioner to file the appropriate petition with all necessary document annexed. Yes.
Item 5.
It's obviously 5/2022 फाइल करने order annex of 2 wheelers. 24/5/22 उड़ा question थी.
कोटा कहले?
Item number मतलब page 14 my lord.
Item 5.
ना से जो मतलब 4 रहा. Item number 4 my lord.
हाँ.
Annex of 2 page 14.
फाइल करते हैं.
हाँ. Charge sheet cognizance order देखी.
Cognizance order. हाँ.
But charge sheet has not been filed.
Cognizance order where is that cognizance?
Charge sheet देना है.
खाली annexer 1 लिखाई थी. Copy of FIR. Where is annex?
चार्ज शीट देना था कि तो कॉग्निजेंस ऑर्डर का देखिए
कहीं कॉग्निजेंस
और पेज 14 है मो पिटिशन देखिए
14
14 पेज
इट इज लाइन किसी
इट 14 पेज और देखिए
अच्छे 14 इट इज कितने कट दी इट अच्छी मोर
चार्ज शीट है देना फाइल चार्ज शीट
राइट Land Counsel for the petitioner seeks to withdraw the petition to prepare a better petition with better particulars and necessary documents.
Item 5.
My lord, the petitioner has been filed this case for quashing of the criminal proceeding under the ground of amicable settlement between the parties.
Where are they?
My lord, both are residing husband and wife. My lord.
Where are they?
My lords, I am appearing for the victim, my lords. I have instruction to appear before this honorable court on behalf of the victim, my lords. So, learned state counsel for the petition may be directed to serve a copy on me. And in the meantime, I will file my Vakalatnama as well as my affidavit, my lords.
It's not settled then?
Yes, it is settled, my lords. I will file the details of the settlement, my lords.
Mr. Raut, Land Counsel for the Land Counsel states that he would be entering appearance for opposite party number 2 and 3. 2 and 3. 2 and 3. The next paragraph. The matter has already been settled. The parties would appear on the next date of hearing. Release the matter on Sanction.
My lord, miss case for no courses.
Bring them. Settlement.
My lord, date
376.
date may be fixed.
Date, we are fixing date.
Fine.
Next study आगे तक कर दिए. Bring them.
My lord,
finish
my
it
lord.
up.
Obli.
Item 6.
6, my lord. Kindly take note tomorrow, my lord, along with my lord, CLMA number 266 of 2023, my lord. Similar petition and the same case.
Coming up tomorrow.
Tomorrow, my lord.
Is it
Okay,
listed
along with
tomorrow?
CLMA 26623, my lord.
Is it listed tomorrow?
No,
Huh?
That matter urgent tomorrow.
urgent.
Is that matter listed tomorrow?
Yes, madam.
Sure.
Yes, I'm checking.
Sir, serial limit tomorrow ko chili.
No.
Along
Along with my lord, this matter. Adjournment.
So how are you deciding the date yourself? Tomorrow, how you have decided? Leave something to the court also.
I want tomorrow, my lord, lordship.
Leave this matter along with so and so. जो डेट अवेलेबल हो सेंटर में हो.
Sorry, that matter. Which my lord? Day after tomorrow.
We'll see how we can accommodate. You are seeking adjournment. Adjournment is granted. That's all. Yes.
Item 7.
नंबर टा नहीं जो.
266.
देखते 11. ठीक है. 7.
Item 7.
That's item 7, my lords. The second item I am appearing, my lords. Item 7, my lords, there are two items, my lords. First item is there, and the second item is there, my lords. But it's the,
You are appearing for whom?
I am appearing for the petitioner in the second item, my lords.
What is this matter is about?
My lords, this is a matter in relation to a family feud between the parties, my lords.
Item 7 may be passed over, Miss Patra. Instructed.
There is a request of pass over. Okay.
My lords, it may be posted to tomorrow, my lords.
Not tomorrow.
Or else, my lords, maybe adjourned to some
Either today or after vacation.
after vacation is also fine. No interim order is there.
Let counsel for the petitioner seeks adjournment. This is the matter after vacation. 8.
Item 8.
Please, here, my lord, matrimonial dispute, my lord. Now, the lordship issue notice, the matter has been now, in meantime, the matter has been compromised. Person only issue notice.
Where are they?
I left here.
Bring them.
The notice.
Mr. Patel and counsel for the petitioner submit that is a matrimonial dispute.
Yes, madam, 498, 40.
Submits that the dispute is arising out of a matrimonial dispute and the parties have settled their dispute. Issue notice to, you have not implicated opposite party?
Yes.
Every time you do like
I
this.
implead.
What?
I implead.
I'll issue notice
Yes,
to
sir.
whom?
No, file for the next question.
Court record.
Now you do it and issue notice.
Yes.
Learned counsel, Mr. Patel seek permission of the court to implead the informant, wife, as opposite party number 2. Let him do so during the course of the day, and by him, issue notice to opposite party number 2, returnable. Proper address given to.
Yes, sir.
Next.
Item 12.
Yes.
May I please? My lord, filing for the IA for correction of the some typographical error. My lord.
What is that?
My lord, the account number is mentioned 1125.
Which order, sir?
My lord, I am challenging the order passed by the learned Special Judge Vigilance Bhubaneswar by rejecting my 457 CRPC petition for release.
Which order you want correction?
My lord, not correction the order, my lord, correction the CRLMC petition, my lord.
There are some.
My lord.
You correct it. Then counsel for the petition seeks an adjournment in order to carry out some correction in the present typographical correction in the present petition. Adjourned.
My lord, IA is filed, my lord, for correction the same, my lord.
The IA is allowed.
Deeply.
The correction may be carried out.
Deeply.
Okay.
13.
May I please, my lord? May I please, my lord?
Yes.
Item number 13 is Belgium matter, my lord.
Yes, yes.
Belgium matter, order dated 14/3/2023, wherein the NBW was issued against the petitioners.
When you got the bail?
I got the bail in the year 2017 for petition number 1 and petition number 2 in the year 2015. And the case is at the stage of argument, my lord.
No, it's all right, but you don't have the dates, huh?
My lord, I have pleaded, my lord. Paragraph 3, F4.
Yes. Write down. Petitioner was released on bail on 14/12/2017, and petitioner number 2 was released on bail on 13/4/2015. And NBW was issued on 14/3/2023. 500. Allowed. Set aside and allowed. Yes.
Deep place. Grateful.
Item 14.
May I please, my lord?
Yes.
May I please, my lord?
Yes.
Item number 14, herein I'm challenging the order dated 4/11/2023 passed by the learned additional district and session judge Koraput in criminal revision number 5 of 2023, wherein the revision petition filed by the petitioner was rejected. With the due permission of the lordship, the facts of the case is a 125 application was filed by the respondent number opposite party number 1 and 2 for maintenance, which was allowed. Consequent in the year 2017, consequent upon which in the year 2022, she came up with an application with under 125(3) for realization of the entire area maintenance, to which the present petitioner entered appearance and filed the objection that the proviso to 125(3) is for the last preceding year, and he deposited the said amount. But the learned court below, if your lordship pleases, then lordship may kindly have a glance to page number 14.
14, yes.
14, whereby last 5 lines from below to top.
Yes.
As in the above circumstances of the case, the present petition filed by the learned counsel for the opposite party is not mendable, and the petition since rejected having no merit. Further, the opposite party is directed to pay the rest amount. The amount was to the tune of 1,80,000. I have deposited.
One fact, substantial of the case, please. 10% filed by the but not 22. Yes. Next.
So the preceding 1 year, I have filed the maintenance amount, that is 48,000, to the tune of 48,000. Thereby, the learned court below rejected my plea with regard to the rest area maintenance, for which I preferred a criminal revision.
What is the arrear amount?
Arrear amount is of 1,32,000.
Yes.
Out of 1,80,000, I have paid 48,000. The rest amount is 1,32,000.
Okay, I'll issue notice. Keep on. You have to continue paying the maintenance. Monthly maintenance.
I may pray, my lord. There is an IA for stay of further proceeding. Why? Because the rest 1,32,000, particularly in this case, cannot be recovered. With the,
why?
With the apex court's judgment, which was quoted by the learned court below, even the Pongari case of 2013.
Why? It is beyond the period.
I bow down, my lord. It is beyond the period, that 1 year period, because your lordship may kindly have a glance to my application, my lord. I filed it.
Okay, I'll issue notice in both application as well as the main petition.
My lord, if stay won't be granted because what I have informed and I have applied the certified copy of the same, the salary was being attached of the present petition. So once and why this petition is not maintainable? Because, my lord, simultaneously she is following 125(3) and also instituted a civil suit. Both are pending.
Civil suit for what?
For recovery, money suit.
Money suit.
My lord.
Okay, in the IA number, which is the IA? IA number?
IA number is, my lord, 3462 of 2023.
Yeah, 3462. Then comes for the petitioner submits, but the areas of maintenance sought to be enforced cannot be enforced against the petitioner beyond the period of 1 year. Beyond the period of 1 year. As per the where is that judgment? As per the judgment, which judgment? Where is that?
Judgment, my lord. It was referred in the page 21. Page 21, my lord.
As per the judgment in Kuldeep Kaur versus Surinder Singh, 1989 1 HCC 405, 405.
And Pongadi,
Issue notice to opposite party number 2, written also. In the meantime, what is to be stated? In the meantime,
proceeding, my lord.
the proceeding pending before the
Yes.
further proceeding in MC case number 99 of 2022, pending in the court of SCJM Koraput, is stayed to the next date of hearing, subject to petitioner continuously making the payment of the maintenance awarded in favor of the opposite party. Monthly maintenance you keep on paying.
I have paid, my lord, 48,000. I will take 2,000 was awarded. I will pay that.
Whatever amount is there, you keep on paying.
My lord.
Yes. Next.
Adjournment.
Which one?
This one, 14. actually.
Adjournment. Which state? Yes.
15.
My lord, petitioner challenging to quash the order dated 3rd October 2023.
Yes.
Passed by JMFC Contabanji.
What is this order?
Due to default of advocate petition quashed. Can you see Amicable?
Complaint not present, my lord. No step taken. And several opportunity given.
My lord, due to
the complaint petition dismissed.
My lord, due to family member surgical family member suffering from brain stroke, petitioner frequently traveling to Visakhapatnam, so they are unable to appear in.
Where have you written it? Where have you written? Where is your application?
Petition lecture.
Where is your petitioner? Where have you said?
Lecture.
You could have moved the application. Yes. Where have you said? Complainant have got the SB account number so. What is this complaint is about? 138
Enact.
Where have you said that you suffered?
My lord, kindly see page 9, paragraph
9. Okay.
11.
9. Yes. Acha. Okay. Right on. The petitioner is agreed by the order dated 3/10/2023, passed in ICC case number 1 of 2022 by the learned JMFC Kantamanji, whereby the petitioner's complaint under section 138 NI Act has been dismissed for non-prosecution. Let counsel for the petitioner submits that the petitioner the complainant was suffering from brain stroke. Therefore, he was under treatment in some hospital in the Visakhapatnam, for which he has been frequently visiting to Visakhapatnam for her treatment. Therefore, he could not prosecute the complaint case. In the present petition in para 11, the petitioner has made the following averments. Okay. Para 11 to the petition. Taking into consideration the explanation offered by the petitioner for not able to prosecute the complaint, I am of the considered view that the complaint need to be restored to its file, and the need to restore to its file. Accordingly, the who is that court? That court is JMFC Kantamanji is directed to ICC case number 1 of 2022 is restored to its file, and the JMFC Kantamanji directed to proceed with the complaint case as per law. Allowed.
16.
16
pass over.
16 pass over.
For dismissing that case, my lord, the Lord Master should have issued summon to the complainant.
Yes, what do you want, sir? 16? Passover may not reach. What is this matter, by the way?
Question of the order of cognizance.
Cognizance. Tell me what is there?
In this case,
Cognizance taken in 2017. Today you are coming. What is the stage of the trial now?
I don't know. Let us.
2017 cognizance is taken. By now, trial might have.
Progress.
Passover might. Don't know the fact.
No, you see, the petitioner is challenging the order dated 4/9/2017, whereby the court below has taken cognizance for the offences 4/9. Where is that? 4/9/2000. Where is the order? 4/9/2000. Offences under section
364A.
My lord. In this case, 364 capital A oblique 452 oblique 341 oblique 323 oblique 294 oblique 506 oblique 120B IPC. 2017 ଆଜି କେତେ ହେଲାଣି 2024 କେତେ ବର୍ଷ ହେଲା
7 years.
Huh?
My lord,
7
in
years.
this case,
7 years.
what has happened? Come to annexure 4, my lord.
You tell me the stage of trial first. I will not proceed further.
Let it Passover or there?
7 years by now has already been passed, and the petitioner is not able to inform this court regarding the stage of the trial. Let the matter be called up on such a day. Meanwhile, Mr. Ragada may seek instruction regarding the stage of the trial.
Let it reach Passover. My lord senior will come.
I'm only adjourning to know about the stage of the trial. I'm not dismissing. Don't worry. Mr. Ragada will get the information. Yes.
17.
Yes.
Item 17, may I please, your lordship?
Yes.
Your lordship, basically, it is a case, it is an application of 482 where the petitioner challenges the quashing of the entire proceeding in Bidanasi PS case number 135 for 2023 corresponding to GR case number.
Why?
Your lordship, it is basically, if I'll explain the factual aspect, your lordship, it is basically a case arising out of a law.
Investigation is still on.
Your lordship, the charge sheet has already been filed.
Where is that charge sheet?
Your lordship, prior to filing of this, the charge sheet has been filed recently, and the only alleged offense is under section 363. And your lordship may kindly have a glance to the annexure 2. The informant, after knowing that her daughter was in a love affair with the petitioner, she filed this affidavit. Your lordship may see the operative part is the para 4 of the affidavit.
That my daughter disclosed before me that has love affair with Deepak Naik, Rabindra Naik, so, and has left the house. He is the informant. Father.
Your lordship, mother is the informant.
Mother has not said it. She is Appu Naik.
Your lordship, she is the mother. Her name is Appu.
What is the age of the child?
Your lordship, she is above 18.
Oh, 18. Where from I get it?
Get
the charge sheet. Get the charge sheet, then only I know.
Investigation is not completed, my lord. Investigation is going on.
No, the charge sheet has already, as per the instructions from the lower court, charge sheet has been filed.
Submits that after investigation, charge sheet has already been filed in the present case. He would be placing on record the copy of the charge sheet, reach the matter.
Item 19.
My lord, may I pray something? Your lordship, instead of filing the charge sheet, I am praying for a liberty that this matter can be settled in the law before the JMFC 3. Because already the affidavit has been filed to that extent, and as per the instructions, the charge sheet has filed only the alleging offences under section 363.
No, how can we settle? The offences are serious offences.
Your lordship, only the alleged offences under section
It's not
363.
compatible. 482 code only can pass.
Or else your lordship may keep it.
So therefore, you
any.
file the charge sheet. Let us see, and we'll pass it.
Right.
Okay.
Obligatory.
Or bring the.
Your lordship may direct the same thing that.
Why should I direct it? Settlement you have to bring.
No, your lordship. On the next date, I'll file the charge sheet.
And bring here.
And I'll.
Bring her here.
Oh, as your lordship.
Bring it.
Challenging the criminal proceeding and the issuance of process matter. The offense under section
323, 509, 354, 504, 506 by
Yes.
34 of IPC, my lord.
Hmm.
The entire allegation against the principal accused, my lord, that is one Prasad Kumar Chatoi. The present petitioner happens to be the wife of the principal accused. The principal accused, my lord, he is running a nursing school, my lord, and he is working as MD, my lord. And the informant is the student, my lord. And she made the allegation against the principal accused and other accused, my lord. Thereafter, my lord, she also made a representation to the collector Navarampur, my lord. And after Navarampur collector, my lord, he has formed a committee, my lord. And the committee has given the report that is under Annexure 2, my lord. Annexure 3,
3.
page 35.
What is this?
The findings of the committee, page 39, my lord. Paragraph 1. May I place that, my lord?
Yes.
Again, during the inquiry, some students were contacted to know about the study, environment and attitude of the teaching and non-teaching staff towards all the students and about behavior of the Prasad Chatoi. All the students present denied the allegation level against the MD and other are false and baseless. In this situation, no student has any issue except that one particular girl student.
Except that one particular girl student.
My lord.
The girl student has said something.
No, no, my lord.
That's the problem. That's what it says.
Yes, my lord. The committee.
The institution has, it says, in this institution, no student has any issue except the
that
one particular girl.
particular girl.
That's the offense against you.
My lord.
The girl student has made allegation against you.
Even taken that consideration, that allegation against the principal accused, my lord, who is the MD of. I am the wife of the principal accused, my lord. I am a government employee.
Let us see the charge sheet.
Yes, my lord.
What is alleged against you? Which is the school?
Nursing
school.
Let us see.
Nursing college.
What have you done? Yes. Come to the charge sheet. Come to the charge sheet, para 16 of the charge sheet.
Page 31. Page 31.
Right in the middle.
My lord.
After departure of the sub-collector Navrangpur conducting the inquiry
My lord.
from the Chotoi Nursing College,
My lord.
they said
Chatoi
sir, his wife, that is you,
Petitioner.
and the brother-in-law, torture on her in different manner. Brother-in-law of Chotoi sir always enter inside the girls' hostel and without permission and instigated some girls against her, made baseless allegation against her. Since last 3 years, she was tortured by them and she reported the matter to the district magistrate Navrangpur, and matter was under the process of inquiry. During the current month, the hostel warden forcibly snatched her mobile phone from her and she is suffering from illness. Her father had provided a mobile phone to contact with the doctor. All these things.
No, my lord. Your lordship may call for the entire statement of the student, my lord. All the students denied the allegation.
All the students, but
students, my lord.
During is a girl student. One
that is a part of investigation, my lord. That is a part of investigation. The students' statement are. That is not with me, my lord.
Where is the student statement?
That statement not with me, my lord. Lordship may
Where is
call
that
for
student?
Call for the case diary, my lord. In the case diary, that is available.
You file it. I am just issuing notice. You file it. Let us see if you can settle. There is any other allegation of sexual assault and all?
No, my lord.
354 is there.
Yes, my lord. Present petitioner is the government employee, my lord. He is working as a
that lady.
Yes, my lord. This petitioner, my lord. This petitioner is a
why don't you settle?
Because
allegations are not much harassment and all.
My lord.
But why don't you settle? Yes, Mr.
My lord,
allegations are not much.
My lord, the
wife, brother of Chotwa sir.
My lord.
And wife.
My lord.
Against wife, there is no specific allegation.
Wife supporting, my lord, the.
No. Since she is a government employee, my lord, for that reason, her name has been included in this case.
As per government employee doesn't mean you have immunity to all.
No, my lord. I don't say like that, my lord. I don't say like that. This is about finding of the sub-collector is that, my lord, against the informant, my lord. Not the petition.
I'll simply issue notice. You persuade. Persuade.
Lordship may stay further since he is a government employee, working as a staff nurse at Navarampur Hospital.
You go and persuade that girl.
No, my lord.
Persuade that girl.
Difficulty is that, my lord, she is not able to work, my lord.
She is a government employee, my lord, working as a staff nurse at Navarampur Hospital. I have taken that averment in also.
Where is your application? Where have you said that? Mr. Gowda, just see in the charge sheet whether any specific allegation made against her. If any specific allegation
No
is
specific
made, then
allegation
no
is
question
not
of
there, my
stay.
lord.
Wife of MD had visited the hospital. She suspected that MD sir, his wife, belongs to medical staff, so she anticipated danger from them. Our parents arrived there and shifted the Visakhapatnam. She came to know that Mr. MD disclosed before press that she and her father are psychiatric patient, and this is a question of how the MD know that they are psychiatric patient. Previously, she, along with the other college students, went to the psychiatric ward for the trying to kill her directly, indirectly.
Who is that girl?
The MD, my lord, MD, my lord, went to press and declared that the complainant is a psychiatric patient. Announcement, my lord, the mental torture, my lord.
If you notice.
Page 8, my lord,
opposite
paragraph
party.
15, my lord.
In the meantime, the petitioner may move application before the court below, seeking an adjournment owing to the fact that the present matter is sub judice before this court. File the
Page 18, my lord, paragraph 15.
Is
I have
there any
taken
one
that
court statement and all?
I'm asking first time in this stage.
So if you notice, short date, please. With it.
P2. Item 20.
Item 20 prefer password, my lord.
Password today may not be possible. 133 matters are there.
My lord.
Tell me,
My friend is coming from Bhubaneswar, my lord. Therefore, I am paying, my lord.
No, what is this matter is about? That is a causing of order shown through 13/9/2000.
NDPS matter, my lord, co-accused persons acquitted. And
on that ground, he seeks
56 for passing.
Absconder.
Absconder.
Just see the judgment. In the judgment, whether chemical analysis report was filed there already in this case or not. If it is there, then nothing could be done. Para 9 of the judgment. 4250 not complied.
My lord. Mandatory provision of compliance, but that is the matter they have been acquitted. Class 17. Though the evidence withheld 10 to claim that the alleged contraband article is nothing but a ganja, but to substantiate said claim, no chemical report was produced, my lord. Page 17. That's
they could have. Why to subject him to?
My lord. That's clear. In case of a hand, the prosecution, though evidence withheld 10 and 14, though claim that they allege contraband article nothing but ganja, but to substantiate the said claim, no chemical report was produced.
Then why to put
So,
him to?
Cannot presume if an article has been seized.
Para 17.
My lord, 17.
You are what is he? Just see.
3 persons.
Three of them.
My lord.
What was the role attributed to them? What we will do is what is the recovery? Just see the recovery.
52 pages.
Recovery. बेसी ना कम
48 kg, 200,
Yeah, 40.
48 kg, 250 grams contraband ganja, including bag.
Okay. Including 48 kilo.
My lord.
बेसी भी नहीं.
Nah.
So what we will do is NBW has been issued.
Man, must have been, since suspect showing absconder, NBW must have been issued against them. Lord.
Expedite the trial and what do you say? Trial expedite or was it? No, see, there is nothing.
My lord.
There is nothing.
My lord.
Even if you put them to trial, nothing will happen.
My lord.
It is wastage of time.
My lord.
You have no chemical analysis report and nothing. You tell me when the NBW was issued.
Fact, my lord, who is doing this matter? He's coming from Bhubaneswar, my lord.
Pass it over.
My lord. Oblige, my lord.
Yes.
Based on the confession statement, pass out.
Pass out will impose cost and
21.
May player.
Yes.
Well, item 21, 22, and 23
Hmm.
are arising out of a one matter, my lord.
Hmm.
This is a matter where the police personnel went to arrest one accused. And at that time, one tenant was there who is an advocate. And there was a tussle between the police personnel and advocate.
Hmm.
Thereafter, the police personnel took him to the custody and for which there was a tussle between the Bar Association of Soro and the IAC of Soro PS. And there is an allegation that at that time, while the advocate in the custody of the police, they have misbehaved, and one police personnel from Bhubaneswar, he also slapped him. That is the allegation. The entire scenario is that.
How three cases? Why?
First case, the first case was filed by the tenant. Second case
Tenant was a
advocate.
Advocate, okay.
Second case was filed by the in-laws who are the owner of that, against whom
In-laws
of the petitioner
advocate.
number one.
Advocate.
In-laws of the petitioner number one, who is the informant of that 498 case, on which basis the NBW to be executed to arrest the husband. The police personnel from Bhubaneswar went to arrest the husband on the basis.
Husband is the lawyer.
No, the tenant is the lawyer in the husband's house.
Okay.
And the in-laws are there.
Hmm.
So in-laws lost one affair, another affair was lost, another complaint, 3 complaint cases have been filed. And the police personnel who went there and they have obstructed on their work, for which the police also lost affair against the advocate and the in-laws.
Hmm.
And the informant who went there, they have also misbehaved by the lawyer, for which she also lost the affair.
What are the offences, by the way?
354, 294, 379.
In the first FIR.
On 3 complaint case. First affair was there. As per 210 CRPC, once one affair has been lost, then all the complaint case should be stayed till the investigation completed in the first affair. Because in the entire scenario, first affair was lost by the police, as they have been obstructed from their work. And for which we have filed, when the person went on behalf of the accused person, one counsel from the Cuttack went to Soro, they have not been allowed to be appear there. For which we have sent it through the postal. That was also not been entertained. And Soro Bar Association on strike for 1.5 months for this reason. Thereafter, we have filed a transfer petition here in the year 2021. The matter took up by the coordinate bench.
Why don't you settle?
Yeah, that's why the settlement has been done. The court has been directed to the counsel who have appeared for the advocate and bar association, and they have stayed on the court. My friend was there on that day in the coordinate bench, and they have said that. He was there. So courts instigate, as your lordship said, why not you settle? Then he said that you filed 482, we will settle.
Bring them.
And they are now not receiving this petition, while I am want to supply the Sujatan Divedi, who is in that TRPCL. He is saying that now they have taken consent from me. This is the entire.
This is the first petition.
3 petition, 3 complaint case.
21,
22, 23.
22, who is the opposite party?
22 is the tenant. 21 is the in-laws. 23 is the bar association. One of the lawyer of the bar association.
So then, shall I direct the IIC to serve the copies, the notice to the opposite party?
But it will not better, you will see notice and send it to the High Court.
Mediation.
Mediation.
That's what I'm saying.
That is better.
And they also, well, 1 second, they also receive notice to the.
Now also in the TRP cell, they have already appeared. I have also mentioned in that.
It's all right.
Yeah, for that,
21, 22, 23. All these three matters are connected matters, and the
I'll solve extra copy to him. They will solve through the.
Nice.
Nice.
Mediation notice. You don't simply send it to mediation will send notice.
And the between the lawyer, bar association, and private parties.
And police personnel.
And police personnel. The parties are there is all probability that the matter would be settled through mediation. The notices were issued to the opposite parties in all the three cases. However, the same could not be served. The issue notice to the opposite parties in all the three cases. And
in transfer cases,
service should be service on the opposite party may be affected through the IIC. Which IIC?
Soro.
IIC Soro. IIC Soro. Next product. The matter is relegated to the High Court Mediation Center. High Court Mediation Center. The coordinator of the High Court Mediation Center is also directed to issue notice fixing the date of mediation to all the parties, and after the mediation is awaiting the mediation report.
No coercive action.
In the meantime, all are investigating stage.
All in the complaint case, 1CC case.
The proceeding in all the 3 1CC case. Number are taken out till the proceeding that stage.
Extra copy.
And I will solve the extra copy. You'll also be directed. I will solve the extra copy, not to issue notice. I will solve the extra copy to AGA. IST question
on the
Mr.
Three copy. ICC case number. So further
in all three cases, I will solve the extra copy.
Three copy. Further proceedings take.
24.
May I please? Challenging the order of cognizance stated 3-9 on the ground that the Family Court has declared the marriage null and void. The Law and Trial Court has taken cognizance under section 498, 323, 506, 34, and 4 defect. In the meantime, the decree has been passed, and the Law and Family Court Cuttack has declared the marriage null and void. Already in view of P. Sikumar and versus State of MP, the Office Court held that if the marriage declared null and void, the offense 499 for defect is not sustainable.
When the FIR was lodged before this judgment.
Yes, Lord.
And this I don't know whether it is appealed or not.
No, Lord. No appeal is filed.
Right on. The petitioner is petitioners are seeking passing up for the FIR. Quashing up for the cognizance order dated 3/9/2016, passed in GR case number 578 of 2015. 15. The present case is arising out of an FIR. PS Jagatpur.
Yes, Lord.
Number 164 of 2015 under section 498 capital A. /323/307/506 of 30.
307 already omitted in the charge sheet.
Full sir.
Charge sheet has been submitted under section 4.
Charge sheet
has been submitted 498, 323, 506, 34, and 4 defect.
498 for defect also.
So,
Baki of
Baki, my lord, the allegation is that
whatever 320, I am not examining that.
Yes, ma'am.
320 and all. I will issue notice.
Yes, your lordship.
ठीक है ना? Then counsel for the petitioner submits that the petition filed by the petitioner seeking declaration that the marriage between the petitioner and opposite party petition number 1 and opposite party number 2 or to be nullity under law has been allowed by the family court Cuttack by its judgment dated 1/8/2023 in civil proceeding number 645 of 2016. Relying upon the judgment.
P. Sikumar versus State of MP.
Right down and relying upon the judgment of the Supreme Court in the matter of so he submits that once the marriage between the parties are declared to be nullity under law, the offences under section 498A and DVS and section 4 of DVS cannot be fastened against the petition. Issue notice to the opposite party number 2, returnable on charge. Yes.
25.
May I please, Your Lord? My Lord, charge seated since 2013. It has not proceeded further. So may I pray your lordship to issue notice?
2013 charge sheet.
Charge sheet.
Cognizance has not been.
Cognizance has been taken.
Right.
Matter has not proceeded. Thereafter it stopped here.
The petitioner had challenged the order dated 26/6/2013. Passed by which court?
SD. SDM Bhubaneswar.
Passed by an
SDM Bhubaneswar.
Bhubaneswar.
My lord.
Yeah.
SDM Bhubaneswar.
SDGM Bhubaneswar in CT case number 1828 of 2013. Whereby cognizance for the offence under sections 341, 323, 354, 294 and 506 IPC was taken.
34 years.
Oblique 34 IPC has been taken against the petitioner. Mr. Charangi, the senior counsel deputy for the petition submits that since then the trial court since then the trial court
Trial has not proceeded.
Trial has not proceeded an inch. Even the charge has not yet been framed. Issue notice to the opposite party written.
Second also similar, your lordship.
26. 26 how could that?
25.
26 is also same. Change
number ta change hobo.
Number would change.
Number ta date ta cognizance date.
27.
Yes, case number 116.
Please, Your Lords.
Yes.
My lords, passing of the criminal proceeding on the basis of compromise.
Where are they?
My lords.
Where are they? Oh, yes, cybercrime.
My lords, on last occasion, parties were present. Your lordships called for the status of the case. My lords, 30,000 is involved. That was recovered from the petitioner number 1. And matter has been settled before the learned court below.
A stage of investigation.
My lord, stage of investigation is pending, my lord. The 2 persons, 2 accused are involved in there, my lord. And one is arrested and released under the bail. And another one, Ajay Kumar Tripathi.
My lords. Petitioner number 2, my lords.
He is absconding.
Absconding and no say for both petitioner, but another.
How many people they have cheated?
2, only 2.
So
but
far.
Cheated, my lord.
No,
now
no,
the cheated persons are they out of 11, my lord. Already 8 numbers cheated persons are stated there one sequence statement, my lord. Now it is 11 numbers persons.
Total recovered. 11.
My lord.
And
As per said, my lord.
investigation only will reveal how many people they have cheated. That's the reason.
My lord,
I said
only
seek instruction.
charge sheet has not been filed, my lord. It is under investigation, my lord.
Mr. Rao, let us consider the petition. Submit that charge sheet has not yet been filed, and he would further seek instruction as to whether, as to when the charge sheet would be filed in the present case. This is the matter.
My lords, may I pray, my lords? My lords, petitioner number 2, my lords, in case of petitioner number 1, my lords, 41A notice was served, but in the forwarding report, the police stated that he denied to receive the 41A notice. I may pray, my lords, the 41A notice may be served on the petitioner number 2. My lords, matter has been settled before the learned SDJ.
Why are you absconding? If it is settled, you go and.
No, my lords, settlement, there was an observation by the learned SDJ at Annexure 3, page 19. My lords, order was passed that the matter has been settled. That settlement order was communicated to the IO, my lords, by the registered post, my lords. My lords, the police is keeping the matter pending and not serving the 41A notice. Petitioner number 2.
How many? I don't know how many people you have cheated. It is a cybercrime.
No, my lords, all the money has been recovered and given to the Jima.
I don't know.
My lords, CD is there. Complete CD is there.
That's right.
And
recovered means what? You have how many years you have been doing it? All nobody knows. Investigation. That's the reason investigation is going on. Land Counsel petition submits that insofar as the petitioner number 1 is concerned. 41A notice was issued to him by the police. He expects that insofar as the petitioner number 2 is concerned, the police would be issuing the notice under section 41C.
41A, my lord.
Sorry, 41A. 41A. Leave the matter. Yes. I have recorded your statement so that they'll get some clue. Yes. 28.
My lords, that I may be given liberty that I will produce such order and I will go on 41A notice.
I have recorded that, sir. I have recorded that. You show that, take this order and give them. I have recorded that.
My lords, in the meantime, that lower court proceeding may be stayed. I have annexed an
investigation is going on, and what is the question of lower court proceeding and all? He doesn't know whether charge sheet is filed or not.
No, charge sheet to file in.
Then
Maybe,
where is
my
the
lords,
trial court? Where is the trial court proceeding? What will I say?
na seiti settlement heichi tala court re ki order has
You tell
been
me
passed.
how many people you have cheated?
No,
If
my-
they are finding out, 11 people have come out so far.
Your lordship,
I don't know how many people will come forward.
No, no,
This is the
say
racket.
10 people ko sangre settlement heichi. Your lordship mein on the
So
last
far,
occasion observed that.
So I have recorded that last
My
time.
lord, my lord.
So far, there are 11 people, those who have come forward.
11 major sufferer is the informant. Se 19,470 ଟଙ୍କା 30,000 ଟଙ୍କା petitioner number 1 ପାଖରୁ
What
recovery.
was your modus operandi?
My lord,
How you have cheated people?
my lords, modus operandi ମାନେ ଏ ହଉଛନ୍ତି petitioner number 1 is a QS को banking agent. ଏ ଗାଁ ଗାଁରେ ବୁଲିକି ଯୋଉ ସବୁ SBI ର ସେ ଏଜେଣ୍ଟ ସେ ତାଙ୍କୁ କହିଲେ ଯେ ମୁଁ ପଇସା ଉଠେଇ ଦେବି 2,000 ଟଙ୍କା ସେମାନେ ସବୁ ଫିଙ୍ଗରପ୍ରିଣ୍ଟ ଦିଅନ୍ତି ସେ 2,000 ଟଙ୍କା ଉଠେଇ ଦେଇ
You should be happy that OPID Act is not invoked so far. Be happy and go. You aggravate it, OPID Act will be involved. You have been collecting money from many people.
ନା କଲେକ୍ଟିଂ ସେଇଠି 2,000 ଟଙ୍କା ବଦଳରେ ଉଠି ଆସିଛି ତାପରେ ସେ ଇମିଡିଏଟଲି ଦେଇ ଦେଇଛନ୍ତି
You
ସେ ଯୋଉ
committed the crime, thereafter you paid it back. That's what your case is. Wait, I am just see. You should be happy that OPID Act so far they have not invoked against you. Yes.
28.
28.
May I please? My lord,
yes.
It seems that the mother-in-law and sister-in-law, they are selling the DV proceedings, your lordship, on the ground that if your lordship will see the statute, your lordship, the three ingredients have to be satisfied consecutively. The domestic relationship and using share household and the respondent. If your lordship will see the definition given in the respondents, your lordship 2Q means an adult male person who is or has been in the domestic relationship. The petitioner, number one is the mother-in-law and petitioner two is the married sister-in-law, your lordship. They have never, so they cannot be your respondents in a DV case, your lordship, as per the statutes. 2Q of the DV Act, your lordship, may kindly have a look. Means any adult male person who is or has been in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief. No relief has been sought against us. And moreover, since they are female members, so they cannot be
You people are also staying in the same address.
my lord? No, we are not.
There is a domestic relationship.
Domestic relationship is there because I am the mother-in-law and that is the married sister-in-law. Never use the share household because the both of
See, complaint cases, you are sharing the same.
yes, my lord, it is there. She is writing.
That is what I am saying. How will I check? Shall I go myself?
No, I am not
Check
saying.
whether they are staying or not. It has to be tested.
My lord, I am not saying
I
that.
simply issue notice, let us see.
My lord,
Because
I can see.
penalty-
But respondent, they cannot be respondents. Your lordship, the statute says.
I am just issuing.
And my lord, moreover, my lord, may kindly have a look. What is the
You
prayer?
don't want notice?
No, I am saying.
Issue notice. Because matrimonial dispute, I am issuing notice, let us see.
My-
Yes. Yes.
And this, in the meantime, the proceeding may be stayed, your lordship, because they cannot, because there is no relief sought for my against me.
All right, you bring them, we'll settle it. We'll send it to mediation and finish it up.
My-
Yes.
my-
29.
Please, Your Lordship.
Yes.
Impugned order is at page 9.
Yes, sir.
Offence is under 420, 120 be read with 34.
Cognizance.
Yes.
Yes.
Lordship saw the order.
This is at page
9.
9. Yes. 120B, 420, 34.
Mal.
Yes.
The allegation against the petitioner is that the co-accused has made a statement that he has taken money from the informant and a part of that money he has paid to the petitioner. This is the only material. He was in custody in connection with a FIR filed by me. Those
You have not
FIR
implicated the opposite party.
Malats?
Opposite party, the informant. We can explore the possibility of settlement. How much? What is the
No
amount?
question of settlement.
What is the amount?
There is no question of amount, my lords. What has happened here is this. This petitioner was the planning member of Sambalpur Development Authority. When she joined as such, a racket was going on, my lords, in which approved plans were being given without being approved at all. She lodged 2 FIRs. They are annexed 3. Khetrajpur PS case 209 and 200.
She was the informant.
Yes. Though on those FIRs, the co-accused were arrested, my lords. And thereafter, my lords.
No, she is not in the annexure 2.
No, your lordship may look at annexure 3.
3.
Yes. Page
Yes.
28.
3, somebody else is the complainant.
I am the informant.
No, the informant is just the annexure 3, page 15.
Annexure 3 is at page 28.
Yajnis Prasad Sahu.
No, that is the FIR in which I am the accused now.
You said annexure 3.
Dr. Yanis Prasad Sahu, my lord.
Yes. Next.
My lords may look at page 28. That is the annexure.
Vandita Mahapatra.
Yes. I filed 2 FIRs, my lords. First FIR is at page 30.
That is page 28. It's on 18/8/2023.
My lords may look at the plain paper FIR at page 30.
Yeah, 30.
I so and so,
Yes. Neighboring authority.
working as planning member, that it has come to my notice that one so and so has submitted a forged approved plan purported to be issued by the Sambalpur Development Authority with forged seal and signature of planning member for availing housing loan from State Bank. Has your lordship seen that? A second FIR was filed, which is at page 35.
This FIR is against?
This is against one Harikesh Bahadur Singh,
Harikesh Bahadur Singh.
who had applied for loan.
Loan. Okay. Next.
Next, my lords will look at page 35.
35. Here the informant is Vandita. Yes, 35. Yes.
Here, my lords may look at the fourth line. One Mrs. Sabita Baghar has submitted forged approved plan.
Same. Sabita Bagar and
She is another person.
Okay.
She submitted. So on the basis of these two FIRs, my lords, Khetrajpur police took up investigation. And they apprehended the co-accused in this case.
In these two FIR.
Co-accused in annexures 2 and 2/1.
Okay.
Now, those persons, my lords, they named me. They said that we have taken money from this Jagyesh Prasad Sahu, and a part of that has been paid to me because I was the planning member there. So I have been taken into custody in this case. And I have been charge seated under 120B, 420, read with 34.
Until now, it is the investigation is open.
I don't know. I don't know whether it is open. That's why I asked your lordship.
It is there.
That is why I asked your lordship to kindly look at the order of cognizance.
Now, last line, just see. Last second.
Lords, before that, would your lordship look at page 9?
9, I have seen it.
No, your lordship hasn't. My lords may look at the third line from the bottom.
Yes.
Cognizance of offense under 420, 120B, 34 IPC is, then this is how
well established. He is well established under section so and so, and cognizance of offense under section so and so is
gas.
Oh, taken must be there.
This is how, my lords.
And the accused person.
This is how, my lords, magistrate sign orders.
Oh, this happens.
This happens. Yes, your lordship may.
Case record is.
Your lordship is taking it casually. I don't mind.
No, not
it
casually.
It happens. It happens. Yes. So it shows what is the application of judicial mind. Does it show what is the application of judicial mind or not?
Do you say that cognizance is not yet taken?
I don't know. I am presuming that it does not
make a statement whether it is taken or not taken.
Who am I to make that statement?
Out of this order, what do you say?
If your lordship,
you say that it is not taken, why are you challenging that?
If my learned friend for the state says so, your lordship says so, then it is taken. I want nothing.
Now you also take it, it is taken, therefore you are challenging.
Yes, therefore I am challenging.
You should notice because she was an officer. In
Of
fact,
course, my lord,
he
but
has filed two complaints, 2 FIRs in 2018. And it looks like it is in a counterblast.
And also your lordship may kindly direct to me obtain the CD also.
You get the CD, we will see. We examine it.
Yes, my lord. Because this petition may not be free from the suspects, my lord.
That's right, because complicated overlapping facts are there. There is no doubt. But apparently it appears she is an officer. She has given complaint against 2 persons. And these two, while investigating, she is roped in.
Yes,
now. Okay, issue notice. And Land Counsel, Mr. Ponda, Land Counsel for the petitioner submits that we would move application for the court below or seeking adjournment owing to the fact that the matter is sub judice before this court.
The petition to move application since we have
28, huh? Yes.
During my intervention to the principal accused Abhimanyu Pradhan, Abhi confessed that except Champa Piasar and so on, so he
28,
along with the
28 where you are reading?
28 from 11 line. From 11 line.
I was also,
He along with the associates namely so and so has committed the offense.
he along with his associate named the so.
The present petition was named by the co-accused Abhimanyu.
Read it once again.
During my interrogation, the principal accused Abhimanyu Pradhan, Abhi confessed that except Chapua PSK Asnavadi, he along with the associates, namely Mahesh Pan.
Yes. You are Mr.
My name is Saki Yokta.
Sakib.
Mala.
Your case is except the disclosure of a co-accused person, there is nothing.
Nothing. As cognizance has been taken.
And the charge sheet has been filed to show this petitioner as abscondment.
No, but he says, if you see the charge sheet, he says that the main accused has disclosed their name. Except that there is nothing.
And the main accused has already been enlarged on bail.
Bail is something different. He challenging the cognizance order. What do you say? What do you have anything except co-accused statements?
Lord, complete CD is not with me, my lord. Only charge sheet.
And Counsel, the petitioner submits the petitioner is challenging the order dated 29/9/2023 passed by which court SDGM Champua in GR case number 165 of 2023, whereby cognizance for offence under section
395 for 12.
39. Where is that order?
Order page 45.
395 and
395 and
412.
412.
412 has been taken against his client. The land counsel petition submits that except the statement of co-accused implicating him, there is no other evidence available on record by which the cognizance could have been taken by the court below. Issue notice NBW has been issued.
Yes, my lord.
You appear before the court and stay this NBW. And argue on charge because you will be discharged. There is nothing.
Yes,
because nothing is there. You have not filed anything except
cognizance statement.
So therefore, better that right out. The petitioner is shown as an absconder while filing the charge sheet. Therefore, the court below, by the order dated 22/9/2023, has issued the NBW at the request of the IO of the case. The counsel of the petitioner on instruction submits that his client would be appearing before the court on or before 30th of May, so and so, and seek appropriate remedy under law. Insofar as the challenge to the cognizance order is concerned, he seeks liberty to liberty to approach the court below at the stage of framing of charges. With this liberty, the second petition is disposed of, and the NBW issued against the petitioner on 22/9/2023 by the STJM Champua is states till 30th of May, so subject to petitioner appearing and availing all remedy under law. Yes, yes. 31.
Yes.
Dixit is there, my lord. Mr. Dixit is there. I am a local counsel here.
Nobody is there.
Some technical glitches are there.
Let's see, somebody is
Appear
there.
for the petitioner in this matter.
31, na?
Yes, sir.
Mr.
Ashish Dixit.
Just see.
Am I audible, your lordship?
You are not clearly audible.
Am I audible now?
You are not to be seen also. You tell me what is this?
Kindly pass over.
You tell me you
You
are also competent lawyer. What is the problem? Tell me what is this order? You have challenged this order.
Yes, my lord. I am the
Cognizance
petition is
order.
challenging the cognizance issued by the GMFC COG to Bhubaneswar, my lord, dated 12/10/2023, my lord. And I have taken some 20 grounds. Out of the 20 grounds, I am harping on this. My lord, kindly see ground number 3. Ground number 3.
3. Okay.
Case 10.
Hmm.
That for that the domestic violence proceeding in CMC petition is liable to be quashed.
You are the husband.
Yes, my lord. On the ground of limitation at section 2832 of the Act, read with Rule 15(6) of the domestic violence rules, made the provisions of Criminal Procedure Code applicable, my lord. And the limitation period is as prescribed under section 468 of CRPC will apply. Kindly see, my lord, 468 of CRPC, section 468 CRPC, my lord.
468.
My lord.
Yes, 468 is that limitation.
Yes.
Yes, tell me.
That is 1 year.
Huh.
And I would like to point out that their marriage was solemnized on, my lord, 7/7/2021. Kindly.
Since it is a matrimonial
my lord,
dispute,
my
let
lord.
us,
And-
I'll simply issue notice.
Yes, my lord.
Who is the opposite party? Number 2.
Copy number 2. She left the matrimonial house on 11/12. Yes,
The matrimonial dispute, I simply issue notice, let us examine.
Lord, I have filed in the IA for stay of the further proceeding.
Right, issue notice to opposite party number 2, returnable also. Then counsel for the petitioner seeks counsel for the submit that we would be moving application before the court below seeking an adjournment. Owing to the fact that the issue is sub judice before this court, we may do so. Leave the matter on suspect. Yes.
32. Deeply obliged.
Bring her, let us see, find it out. And what about have you filed any divorce petition or anything?
The divorce petition filed by the wife.
Why?
Yes, ma'am.
She wants to get rid of you.
But,
Say something and finish it up.
But she's not only she has not filed only divorce petition, but she's claiming huge maintenance.
What are you doing?
Like the businessman, small businessman. Earlier he was in IT.
When it comes to paying your
No,
you become very small businessman. While taking loan from the bank, you are very big.
No.
That's always happen. Pay something and finish it up. That's better. Yes. Next.
Yeah,
30?
yes. Petitioner has been implicated in a case under section 13(2) read with 13(1)(c)(d) and 409 and 120(b) of IPC mallet.
Yes.
Here the allegation was that while he was working as a Gram Panchayat technical assistant, they have misappropriated along with the co-accused person 3 lakh some odd amount for the construction of CC road, my lord. And thereafter, my lord, the petitioner was released on anticipatory bail, page 31, annexure 3, my lord. In the event of arrest, the petition shall be released on bail, my lord. Now, my lord, now cognizance has been taken and summons has been for appearance, my lord. That order was in the event of arrest. So I prefer should go on bail, surrender and go on bail because
That's
was
always there, but
in the end of yes, my lord.
That's a let account for the petitioner submit that you were an anticipatory bail.
Yes, my lord. It's annexure 3 ABL 9570 of 2000.
Where is that? Where is that?
Annexure 3,
Right.
page 31, my
Right.
lord.
Order dated.
Order dated.
Order dated 22/9/2023. The coordinate bench of this court, while allowing ABPL number 9570 of 2023, has been enlarged the petitioner, has granted the concession of pre-arrest bail. Granted the concession of pre-arrest bail. After next problem. After investigation, charge sheet has been filed in the present case on. Charge sheet is filed on.
Charge sheet and filed on my lord.
13/12/2023.
Yes, ma'am.
The court of SDGM, court. The court has taken cognizance.
Special judge, my lord, additional district and session judge come
The
special judge
additional
vigilance.
Additional
Full
district and sessions judge come the special judge, vigilance full money. While order dated 8/1/2024 has taken cognizance of offence under section 13(1)(c)(d) oblique 13(2) of PC Act, read with 409/120B IPC, and issue summons to the petitioner. Also, the petitioner is challenging the said order dated 8/1/2024. We say that I'm not inclined to interfere in the matter at this stage. However, the petitioner may appear before the court below and apprise the fact that he has already been he has already been given the protection by this court while allowing his heavy APL number 9570. With this observation, the petition is disposed. Yes.
33. Yes.
133 CRPC removal of obstruction of the petitioner. The Counsel Annexure 7, page 27.
Yes.
They submitted a report before the Sub-Divisional Magistrate Anandapur on 31st/10/2023, page 27.
27.
Yes. Annexure 7.
Yes.
So, criminal mistakes 158/2023. So, following said, my lord, the encroachers and those who have obstructed the public passage in front of my house. So, I pray, in response to the, my lord, the report of the Tahsildar Attorney addressed to the Sub-Divisional Magistrate Anandapur. So, the action may be taken under section 133 because on the basis of the order of the, my lord, the SDM, the Tahsildar has inquired into the matter. So it is the lookout of the sub-divisional magistrate to dispose of the, my lord, criminal case 150/2023.
Why have you not told these facts to the court below? Straight away came to this.
My lord,
Before SDGM.
My lord, it is done. It is done.
Where is that?
My lord, the Annexure 8, one petition is filed.
Let us see what report.
Page number?
Page 29.
You have moved an application. You have moved an application. This is not disposed of.
It is not disposed of.
Right.
But
the grievance of the petitioner is that on 14/11/2023, and he has moved an application before the sub-collector of sub-divisional magistrate Anandapur. Anandapur. The said application has not been decided. Therefore, when the counsel for the petitioner submits that in the light of the report,
Annexure 7,
report dated 31/10/2023, submitted by the Tahsildar, Atto Dihi. The application moved by him before the court of sub-divisional magistrate Anandapur on 14/11/23 may be disposed of. The petition is allowed. The sub-divisional magistrate Anandapur is directed to dispose of the application dated 14/11/2023, passed moved by the present petition in the light of the Annexure 7, namely the report filed by the Tahsildar, the report submitted by the Tahsildar on
31st/10/2023.
31st/10/2020. Disposed. Yes.
34.
Maybe.
Yes.
Here, I have challenged the order, my lord, page 11, wherein the learned trial court has dispensed with my cross-examination on the ground that I have failed to examine the eye on the particular day, my lord. So the fact remains the investigating officer has not at all been examined. It's a case on 302, my lord. Madam, I'll have a glance to my page 3, para 4, my lord. After conclusion of all, my lord, evidence so far the prosecution is concerned, the date was fixed to 11th of October 2013, sorry, 2023 for examination of the investigation, my lord. Thereafter it was adjourned because of the fact that he has not turned up.
Which one you are reading?
Page 4, my lord.
Page
Sorry,
4.
page 3, para 4, my lord, of my petition.
Page 3 of your petition.
Well,
Yes.
and the IO was payroll 21. Initially, it was fixed to 11th of October 2023. As because he has not turned up, it was again fixed to 1710, then 1810, then 1710, 1810, he was not appeared. Again 811, thereafter 911, not appeared. 1511, not appeared. And thereafter, my lord, the date was fixed, my lord, it was adjourned to 1412, my lord, where she has entered appearance. Because the fact that time was not there, again the processes were not materialized. It was fixed to 22nd of, my lord, of December. And thereafter on 17th of January, she has not turned up. Thereafter the case was fixed to 1st and 2nd of February, my lord. On 1st and 2nd, on the account of the illness of the conducting counsel, a type petition was filed. The court has dispensed with the examination prosecution part, my lord. That is apparent in page, my lord.
Yeah, what is your precise grievance there?
But I have not been cross-examined the IO, my lord. Under 309.
Where is the IO statement?
Statement. But there is evidence, my lord, from the input order, my lord.
Evident and implied and all these things.
No, that is the.
You have filed only proceedings. I'm not able to find out what.
No, the entire order sheet I have filed, Madam Messi. The court has said, Madam Messi, page 13. Page 13.
13.
Okay,
Come
1
to page 11, on the
Madam.
last line.
Madam.
That proceeding dated 1/12/2022.
Madam.
Later, defense counsel also requested the present tomorrow and on 2/2/2012 for cross examination.
Madam.
The IO without fail.
Madam.
Okay.
Madam.
Next date, what happened in 2004?
At this stage, Madam, last line of that para, and Madam went on to that next para.
Yes.
That is defense counsel, adjournment on the ground of illness of cross-examination the lawyer, Madam.
Considering the above submission, right now, and this court has allowed the adjournment liberally,
Right.
but in spite of the defense of
He has said that previous day only, just a day before, he has granted time. Madam Messi, the prosecution has given 5 months, taken 5 months. No, for at least 5 days also not been given, my lord. And my lord knows, my lord, because of
how many days you have taken?
No, not a single time, my lord. First and second, we give absent, my lord.
No. The first cross examination was fixed on
First.
1/2/2024.
My lord.
Okay. Then it was
Next day.
extended to next day.
Next day.
Then
That's all.
next
That's
day what
all.
happened?
Next day, this is the order, Madam Messi. It starts from page 11.
Yes, Mr. Rao, what? See, the matter was fixed on 1st of February 2024.
Yes, my lord.
And he sought time for cross-examining the IO. It was urgent to next day, very next day.
Yes, my lord.
And the next day he moves an application and was rejected. He has indefeasible right.
Case.
I'll set aside it and give a one opportunity.
Well,
IO, he has to
Yes, my lord, one
He
opportunity.
is an accused.
It is a matter of a vigilance case, my lord.
No, murder case.
Huh?
Vigilance case अलग आता है.
Therefore,
Murder
he has a right to cross-examine the IO at least. Right on.
No.
Murder case.
The problem is you have filed the proceeding of 1/2/2024 and 2/2/2024. Before that, what had happened? Nothing.
No, my lord, that is.
Selectively, you have taken out 2 proceedings. And you have filed.
My lord, my lord, kindly see, in such a
Before
case.
that, how many times you have taken? I don't know.
No, this is the order, my lord. My lord, may see. I have specifically said so.
Where is that?
My lord, that page, it starts from page 3, para 4. Each and every date I have mentioned, my lord.
Let me see once
Hi.
again. Para 3.
Again.
Right down. Para 3 to 4.
Sorry, page 3, para 4. I'm sorry. Page 3,
Para
para
4.
4. My lord.
Para 4. And the petitioner will submit that several adjournment. Finally, on 11th October 2020, the investigating officer of the case, namely so-and-so, 11th October.
Page 3.
And was examining proceeding PW so after some examination. So, 11th October, he came.
He came, examined.
To 17th
For the purpose of UD case register, my lord.
17th October.
Again.
1 minute.
Again.
Thereafter, 18th October.
My lord. She has not turned off.
But neither on 17th or 18th October. Thereafter, the matter was fixed on
15/11.
November.
No, 15/11 again.
Thereafter, the also on 18th,
My lord.
8 November, 9 November,
My lord.
10 November,
15.
did not appear.
My lord.
Adjourned to
8/12.
8/12. And time petition was filed for Grado. The grievance of the petitioner is that petitioner is an accused in so and so case under 30234. He is facing trial in the present case. Grievance of the petitioner is he was denied appropriate opportunity, adequate opportunity to cross-examine PW 1.
21 again, 21 again. 21, PW 21.
PW 21. PW 21 is the of the case. In paragraph 4 of the petition, inter alia, he mentions agenda. Para 4 of the petition. Okay. Having taken into consideration the aforementioned averment made in the petition, I am inclined to allow the present petition. Direct the which court?
My lord, additional session judge come vigilance.
Additional sessions judge, district and session judge come special judge. Vigilance.
Additional session judge bracket vigilance Anugul.
Vigilance Anugul. Anugul to afford one opportunity to the petitioner to cross-examine PW 21. PW 21. 21. It is made clear that the petitioner shall not seek any adjournment on any ground whatsoever. When are you going to do it?
After 2 weeks, any day, my lord. Have to move.
The letter court below
Yes, yes,
may fix a date
and intimate the defense accordingly.
for the purpose of cross-examination of PW
21.
PW 21.
And intimate the defense accordingly. Yes. Oblige.
Yes. 35. Yeah.
May I appeal, Your Lordship?
Yes.
In this case, Your Lordship, the FIR was registered under section 13(2) Redo 13(1)(e) of PCX along with 109 of IPC.
Yes.
After 8 years, Your Lordship, the charge sheet has been submitted. Pursuant to charge sheet, the court below has pleased to take the cognizance and issued summon to the present petitioners who are the accused of that case, Your Lordship. And the petition appearance, if pursuant to summon, if they appear, Your Lordship, they will be taken. They are taken into custody.
You are in bail or not?
No, Your Lordship. The IO during investigation, Your Lordship, all the petitioners cooperate with the investigation. Your Lordship may peruse page 42, Your Lordship. Page 42.
So essentially, you are arguing a 438.
Yes, Your Lordship. Because someone was issued, Your Lordship. Lordship, I am relying upon a judgment of Honorable Supreme
That's
Court.
right.
Your
You
Lordship.
may be correct, but you should have invoked right provision. 482, you are seeking quashing, and on the apprehension that
This is
during
molded
investigation
period,
you
Your Lordship.
cooperated, you may be arrested.
Lordship, may I peruse, Your Lordship. Here, Your Lordship, the petitioner is apprehending arrest on behalf of the court, Your Lordship. Not
For apprehension of arrest, what is the provision to be invoked?
because earlier the petitioner approached this Honorable Court, Your Lordship, in the year 2015, Your Lordship, where their application has been disposed of on 30/11/2015 and 4/8/2015, Your Lordship. And during investigation, Your Lordship,
Why are you not approaching the right court?
Because
the right provision.
Because Your Lordship, in 2015, Your Lordship, my bail application has been rejected. One of the bail application has been rejected by this court, Your Lordship. But I cooperated with the investigation, Your Lordship. That's why the IO didn't fail to arrest me. And
file the charge sheet.
File charge sheet is not arrested, Your Lordship. Not absconded, not arrested. And
when your bail application was rejected to me?
Yeah, that was on 13/11/2015 and 4/8/2015, Your Lordship.
How many of you are there?
3, Your Lordship.
3.
3, Your Lordship.
Yes, Mr. Mahavatar, Land Counsel, the petitioner submits that the petitioner had applied for anticipatory bail. Filing what? You give me the particulars.
That is in page 2, Your Lordship.
Page 2, huh?
Page 2 of the petition, Your Lordship.
Right.
That's in the certificate I have mentioned, Your Lordship.
Page 2. Yes. Write down. Petition number 1 and 2, write down like this. Petition number 1 and 2 had filed ABPA number 4996 of 2015. which was disposed of on 30th November 2015, and petition number 3 filed ABPL number 5028 of 2015, which was disposed of on 4/8/2015. 15. Despite that, the petitioners have cooperated with the investigation, and eventually charge sheet was filed on 31/12/2023, showing them not arrested. During the investigation, since the petitioners have extended our cooperation to the investigating agency, therefore they were not arrested, despite the fact that their anticipatory bail application was turned down by this court. In the present petition, petitioner is challenging the order dated 19/2/2024, whereby the cognizance for offence under section so has been taken by the court below. What are you relying upon, Jesse?
I'm relying upon a
Which
judgment.
paragraph?
Madhum Bhava versus CBI, Your Lordship.
What do you want to say here? Which paragraph?
That is paragraph 9, Your Lordship.
Learned counsel for the petitioner, no, relying upon.
And the operating para is 10, Your Lordship.
Para
9 and 10.
Yes.
May I permitted to read? Your
Yes.
Lordship?
What do you want to say? Tell me.
Yes, Your Lordship.
What is the proposition?
The more important is the appellant's arrest, not at the behest of the CBI, but at the behest of the trial court. This is for the reason that in some parts of the country, there seems to be a practice followed by the courts to.
Where are you reading?
Para 10, Your Lordship.
Para 10. 9 you relying or para 10?
9 is the fact of the case, Your Lordship.
10 is relevant.
10 is relevant, Your Lordship.
In case of illegal, Supreme Court so 2023 live law SC 218 Mahmood Bawa versus CVI in para 10 submits that when the petitioner is apprehending arrest on the basis of the summons issued by the court below, and that's in that event also the application under 438 NI Act is maintainable. In view of the aforementioned, the petitioner seeks to withdraw the petition to resort to the right remedy under law, remedy under law, in view of the right remedy under law. The petition is disposed of. The liberty is granted to the petitioner to avail right remedy under law, relying upon the aforementioned judgment and in the people of exception.
Here, Your Lordship, this Honorable Apex Post directed the court below to raise it up on bail.
I have recorded everything. I think I have passed the order leaving the last line. You apply, but 482 I am exercising, so I have recorded.
Your Lordship just mentioned 438. 430 is not applicable before that.
I am not saying that anything. I said that appropriate remedy. Now you take the call. I have recorded everything, your judgment and everything I have said. Yes. So that's enough. You will get it. Don't.
My Lord, trial court file dealing with my application may refer to this.
I said so.
12
You read it. I have given a better observation. Just see. That will really help you.
Para 12 টা মধ্যে কোড কর দাও।
Para 12, para 10 and 12 দুইটা করো। That will be much more. Yes. 36.
Here, my lord, the petitioner before your lordship are the in-laws of
Yes.
opposite part number 2, challenging the order of cognizance taken by the trial court. My lord, no specific overt act has been attributed against any of the petitioners.
Then
all are in-laws, my lord. Husband has not come before your lordship.
98, this is the problem. Mother, 70 years.
ମାନେ ଘରରେ କେତେ ଜଣ ଅଛନ୍ତି ଦାଦା ଶ୍ୱଶୁର ଝିଅର ସମସ୍ତେ
Mr. Rao.
Omnibus allegations also.
The entire family because
Yes, my lord.
husband and wife fight and the mother-in-law.
But there one sticked for statement, my lord, she has stated against all these petitioners.
Issue notice, returnable also. In the meantime, further proceedings what the petitioners are state.
Your lordship has granted the interim order. Your lordship has granted the interim order.
Further proceeding I am staying for these petitioners and bring them, we will settle.
Yes.
Bring them.
37.
Short date they will before vacation is there. So that
Vacation. So.
before vacation you will try, bring them first.
May I
We'll
please,
finish
sir?
it up. The entire matter will finish it up. File the process fee by tomorrow. Don't be so pessimistic. Bring them because these are the matrimonial dispute. It can be settled here. The husband also can you'll be free.
Mediation.
You are saying or they are saying?
Matrimonial case.
Let us.
37.
May I please, Your Lordship? I'm in law, my lord. As per the allegation of opposite party number 2, my lord.
Yes.
Here the offences against the main accused is 376(2) and 498A, 323, 3.
My lord.
Online kar diyo, nahi to bolas.
Next week.
The OP number 2 is appearing. The informant. My lord.
6 will do.
My lord.
Yes. Yes.
40.
6. May I please, Lordship? 311 application was rejected by the London Court below.
Sorry?
311 application was rejected by the London Court below, my lord.
311.
Yes, my lord. That is page 11, my lord. Only page 11, my lord. On 12/2/2024, PW1 informant, PW2 victim, and PW3 is the father, my lord. They were.
Where is your application?
That is page 18, my lord. Answer 3, my lord.
You are in the application, you only say that the defense counsel was not ready.
The case under section 376D and POSCO Act, my lord. On that day, he is not ready and requested to give one adjournment, my lord. But the London Court will not insisted and examined.
Let us see. Oh.
And he has asked you only.
I'm illiterate, I am not. This is PW
1, 2, 3.
Where are the statements?
That is page 12, my lord.
12. This is PW1.
Yes, ma'am.
Cross examination. I'm illiterate, I cannot say the name of the scribe before whom I, in spite of the repeated request made, the counsel for this, the accused did not opt for prosecution. In spite of repeated request made by this court. See what is written. In spite of repeated request made by this court, the learned counsel for the accused did not opt to cross-examine.
He is not ready, my lord. Case
court is requesting you, please do it. You don't do it. And move an application at 311. Next, just see.
Same, my lord.
See?
That is page 15, PW2. Only one question, ma'am.
Yes, Mr.
Yes, my lord. Already one petitioner, PW1 has examined my lord in chief, my lord. So let's see again.
Insofar as the victim is concerned, I am not going to allow.
Yes, ma'am.
In any case. Insofar who is the victim? Victim PW2, I am not going to allow. Because 33.5 is there, I will not allow. In view of 33.5, no? Yes, folks.
17 years old, my lord.
Already has 7 crossed.
No, only one question. I am illiterate up to standard X.
Right on. I could see the photo. Here, this one is photo. White wala. 35? 35 3 na? 35 5. 33 5. Right. Petitioner is agreed by the order dated 26/2/2024, passed by the District Judge cum Special Judge Poksho, Kendrapada, in connection with the GR case number 73 of 2023, whereby his application under section 311 CRPC to recall PW 1, 2, and 3 had been turned down. The petitioner has placed on record the application application under section 311 CRPC, wherein rejected by its own. It appears from the record that the petitioner was afforded opportunity to cross-examine the said witnesses. However, the defense counsel was not ready on that day. Therefore, the evidences were closed. Taking into consideration the averment made in the application and the fact that the petitioners, how many petitioners? The petitioner was not afforded adequate opportunity to cross-examine. I'm inclined to allow the application under section 311 CRPC, except however, insofar as the PW2 bracket Rekha Seti is concerned, she is the victim in the present case. She cannot be repeatedly called for cross-examination in view of the bar contained under section 33, clause 5, subclause 5 of POCSO Act. Therefore, the application vis-a-vis PW2 is rejected, whereas insofar as PW1 and 3 is concerned, the trial court is directed to afford a singular opportunity to the petitioner to cross-examine these witnesses. The petitioner is also directed to furnish the relevant questions to be put to the said witnesses, and the trial court would examine the relevancy of those questions to be put to PW1 and 3, and afford an opportunity to the afford a single opportunity to the petitioner for cross-examining these two witnesses. It is made clear that no adjournment shall be granted to the petitioner for the purpose of cross-examining the witnesses, namely PW1 and 3. Yes, allowed.
41, my lords, I am appearing. Your lordships will kindly have the Domestic Violence Act, my lords. Enhancement may not be done at this moment before hearing both parties. From 10,000 to 20,000, I may continue at the old rate.
I don't know.
The school fees, in all honesty, I am not.
Your wife and children has to lead a life commensurate with your standard.
Her ITR is more than my ITR, my lords. I am an advocate.
What is she doing?
She has some MTech degree. She files ITR more than me.
I give a short date. I'll just give a short date. I'll issue notice, and this side of the vacation is free.
Right.
This side of the vacation we will examine. Okay. Yes.
I'm obliged.
Issue notice, returnable this side of the vacation. Yes. 42.
My lord, I am on VC, my lord, due to some personal difficulties, my lord.
Yes.
My lord, here I have challenged the order of cognizance taken against the petitioner, that is at annexure 46, page 46, annexure 4.
Yes.
Lordship kindly come to relevant portion of the cognizance order, that is at page 47. By order dated 6th February 2024, the Lord Magistrate has taken cognizance of the offence matter under section 417, 323, 294, 506, 3762N, 341 IPC matter. But what happened? The present petitioner is working as a home guard in a Kesingpur police stations matter. The lady approached the home guard, the present petitioner, for writing a report in the way back January 2022. Thereafter, subsequently developed relationship up to 1.5 years. They stayed together for 2 months in a rented house. Whenever the present petitioner refused to marry her, then she lodged an FIR. But the Lordship will see in the FIR, she has stated that they were in physical relationship for prolonged period. Nowhere the present petitioner was forced to join within sex, but as a bed partner.
So then therefore you are saying 376 2N is not made out.
C2 not, because there is no consent, my lord. Because Lordship may see the FIR at the content of the FIR. My lord, page 9.
Come to the charge sheet, where is charge sheet?
Yes.
My lord, charge sheet, my lord, the entire charge sheet is annexure 3.
Yes.
I have filed more than
show me her bail has been granted to you.
Yes, anticipatory bail has been granted to me.
So then why you come? Investigation is going on, anticipatory bail is granted.
Yes,
Your Lordship,
Go there and tell everything.
420 and 468.
Your Lordship can see the cell deed which was registered in the year 2013.
I don't know. I'm not investigating.
Let to complete the investigation.
Your Lordship can take the instruction whether the charge sheet.
Why the investigation is going on? You are protected under 438. Wait till the investigation is complete.
Already 5 years.
You are relying upon so many documents, sale deed and all. Go and tell the investigating. He may close it.
2019 till now no charge sheet is filed.
Right. The petitioner is challenging petitioner is seeking passing of the entire criminal prosecution initiated against him. By the informant, by the opposite party number 2, in PS case number.
Borgard PS case number. 364 of
2019. So, investigation in the present case is still going on. In the meantime, petitioner had applied for anticipatory bail before this court by filing ABPL number 1190 of 2020. While order dated 11/2/2022, this court has already extended the concession of pre-arrest bail to the petitioner. Full stop. Next one. Petitioner, by relying upon various documents, submits that the present case, is basically a civil dispute arising out of a
registration
sale transaction. Therefore, no criminal case should have been foisted upon him. I'm not inclined to interfere in this matter at this stage, since investigation is going on. However, the liberty is granted to the petitioner to submit all these documents to the investigating officer of the case, and investigating officer of the case shall take into consideration the documents to be submitted by the petitioner and take a final call while filing the report under section 173 CRPC.
Well, Lordship, one observation, Lordship. The cell deed which has been registered has not been challenged before the civil court to be.
I've already said all the documents. You give it.
That should be taken in consider by the
filing the charge.
Yes, my lord. That should be taken in consider.
I have said that. Yes. He shall take into consideration all the documents which you are placing it on record, and before filing the charge sheet. He will file the charge sheet accordingly. He may file a closure report also. Yes. 40. What is this matter? Because today it may not be possible after Passover. I may be in a position. Now, what is this matter? Whether it is very urgent, then we will pass it over. I'll cancel the NVW. What is the big deal? Cancel the NVW. Where is that? Where is the NBW order? Show me.
8/8/2023.
8/8/2023.
23.
You was on bail?
No, madam.
You are not on bail. Go and seek bail. Charge sheet was filed. Absconder.
Absconded.
Huh?
Yes.
Yes. Right on. Petitioner is an accused in FIR number, PS case number.
PS case number, Golamthara PS case number 7 of 2021.
7 of 2020.
21.
After investigation, charge sheet was filed
Yes.
against the petitioner, showing him as an absconder. At the request of the IO, the court below has issued NBW against him. While order dated
No, not on behalf of the IO. Court itself issued.
the request of IO. Absconder, he was shown as absconder, that is yours.
No, the order, interim order was passed by this honorable court, and it was placed before this London court below, and thereafter no order was placed before this court.
Why to say
And
all this?
neither he appeared nor.
The charge sheet has been filed, huh?
Yes.
Charge
That
sheet
is why NBW is.
due to absence
Yes.
of the petitioner before the court below. On 8/8/2023,
Right.
NBW has been issued. NBW has issued. On instruction, the petitioner submits that he would be appearing before the court on or before 30th of May 2023, and avail remedy under law. Remedy under law. Right on. Taking into consideration the statement at the bar and facts of the present case, the NBW issued by JMFC Barampur, while its order dated 8/8/2023 is set aside, subject to petitioner appearing before the court on or before 30th of May 2024, and paying a cost of rupees 500 to the bar council. Bar association. Allowed, your petition is allowed. Yes.
My lord, I may be pardoned to, my lord.
Yes.
My lord, I may be pardoned to mention, my lord, that item 42, your lordship has disposed of on a granted liberty me to challenge in discharge petition, my lord. But a earlier occasion 376(2) not there. Now cognizance has been taken under section 376(2), my lord. Earlier I was on bail. Now even when I will appear, they will arrest me, my lord. So lordship may protect me.
Why they will arrest you?
The court below, my lord. No course of action at least.
1 minute. Plain counsel for the petitioner further submits the dispose of 42 days. Further submit that the charge under section after in which initially the offense initially the allegation was not made against the petitioner under section 376 IPC. However, charge sheet was filed under the said provision and cognizance is also taken. Therefore, he apprehends arrest. Arrest. Sushila Devi, what is that?
Sushila Agarwal.
Sushila Agarwal. The petitioner is also given liberty to apply for bail, appropriate right remedy by relying upon Sushila Agarwal and out the Tila.
Satendra until.
Satendra until Tochi. Sushila Agarwal and
Sushila relevant
for until
Obliged.
46.
May I please?
Yes.
Here in this case, the petitioner with the informant in this case, my lord, approached this honorable court. Protest petition was rejected without not true inquiry, my lord.
Where is show me?
Your lordship kindly see
Protest
order dated. Final report was made, my lord. Thereafter, we have on protest petition was filed at page 19, my lord.
Right.
Thereafter, your lordship kindly see order dated 1/2/24. The record is put up today for consideration. The informant has sought permission of this court for filing any protest petition as police have been submitted FRT. The law is well settled that any person who have any grievance against any adverse finding have a scope to ventilate his grievance in this court. As the police have submitted FRT, so opportunity have to provided to the informant for filing the protest petition. Hence, the informant is directed to file protest petition, if any, dated 15 to 24,
Then
so and so. Thereafter, we have lodged, filed the protest petition, my lord.
thereafter what happened?
Thereafter, order was passed, my lord. Your lordship kindly turn to next page, 25. Record is put up today. The informant filed protest petition, shape of 1cc complaint petition along with other document put up later for consideration on the protest petition.
Right.
Heard from the side law counsel for the complainant, also judgment of the Honorable Apex Court through a memo put up later for order. Thereafter, application was rejected.
Why
The
the complaint has filed
Page 27.
Without
Page
202 inquiry, my lord.
Relevant is page 27, you also can see.
Yes, 27.
Last para.
Right.
I'm reading while going through. While going through the 161 CRP statement, as well as the documents which are essential to prove the case, it is revealed that the police have submitted final report for the region that both the families have got conflict and were having previous enmity among themselves. Even on perusing the crime detail form, the same is corroborated. In fact, while perusing the 161 CRPC statement, all the witnesses are seen to be interested witness and none of the independent witnesses are available. Next paragraph, which could have been thrown some light on the case as the incident occurred at about 8:50.
No, that's all right.
Likewise,
The inquiry was not done.
How he has filed a protest petition.
Yes.
The court is taking into consideration the 161 statement. Where is the statement under 200?
say complaint petition को accept college है कि 200
kind, but you have to give opportunity. Inquiry has to be done. You can't do. We'll set aside straight away.
Yes.
No wasting of time. Right on. The petitioner is agreed by the order dated
15 to 24.
15 to
24.
Whereby his protest petition has been dismissed without affording him an opportunity to record his statement under section 200 CRPC or entering into magistrate or the court below entering into an inquiry, entering into an inquiry and contemplated under section 202 CRPC.
Yes.
202 CRPC. In the present case, the final report was filed by the police on 31/7/2023. Thereafter, the petitioner filed a protest petition on 25/1/2024. 24. The learned court below, while passing the impugn order, has relied upon the statement of the witnesses recorded under 161 CRPC and form the opinion that no case is made out against the accused person. The procedure followed by the court below is not known to law. Once the petition is filed, it is obligatory. It is an obligation under law for the court below to inquire under section 202 CRPC and affording an opportunity to the complainant, protest petitioners to record their statement under section 200 CRPC. The same procedure has not been followed, so therefore I am inclined to allow this petition. The order accordingly, the order dated
15 to
2024 passed by the SDJM Khurda in GR case number 214 of 2023 is set aside and the matter is remanded back to the court below for affording an opportunity to the complainant, the present petitioner, to record to leave his evidence, and thereafter the trial court may take appropriate may pass appropriate order.
In accordance with
may pass appropriate order in accordance with the law.
Yes.
If you bring the evidence,
yes. By arising out of 1cc number 24 of 24.
Like GR case arising out of.
Yes. Obliged.
Allowed.
Yes.
47. 47.
May I please the Lord's merit?
Yes.
This is the case best example of the smoke without fire, my lord. Because, my lord, I'm saying, kind of answer date.
You show me the smoke first.
Yes, appendix 2, date chart, my lord.
Date chart?
Yes.
Yes.
On 11/5/23, I got a decree of divorce.
1 minute. Yes.
From the opposite partner of 2.
And you married on 2017?
Yes.
Marriage both dissolved in
11/5/23.
Yes.
Thereafter, it was
was
confirmed through by
Yes.
decree. 18/5/23.
Another girl.
No, 18/5 decree was confirmed. Thereafter, I married on 27/6/23. Then 7/8/20.
That marriage is not legally valid.
Sorry, madam?
That marriage are not legally valid. You have married before the appeal period is over. That there is this smoke.
That is the smoke.
But now appeal is confirmed, my lord.
No, appeal period time.
How have you married? 18/5/2023 you got
Yes.
it.
Yes.
And what is the limitation? Under section 28 of Hindu Marriage Act.
Yes.
90 days.
Yes, my lord.
And you married on 27/6/2023.
Yes.
That is this.
60 days.
The smoke is here.
But ultimately, that decree has been confirmed, my lord, in appeal.
That's a different story. The marriage
Yes.
itself, you have married. See, if you have preferred an appeal.
Yes.
When you preferred the appeal, let us see.
See, preferred an appeal.
After marriage or before marriage?
And the date is not there, my lord.
That date is relevant. When she has filed that appeal against the decree of that.
90 days ପରେ ହେଇଥିଲା admit ହେଇଥିଲା.
Initiation is not there, my lord. But I judgment
sir,
is
Nothing
date of
can be done. Nothing can be done. Because nothing can be. Cognizance has been taken.
Yes. Notice the FR টা
Then
he's
counsel, but the petitioner seeks to withdraw this petition to.
No, my lord, I will satisfy, my lord.
I am
During
satisfied now.
During the pendency of the deport.
Within less than a month, you have married.
My lord, there is also additional during the pendency of the deport petition, a person can also marry, my lord. I will satisfy, my lord.
28 जो sheet 20 section 28 Hindu marriage. Show me Hindu marriage. 28 is the appeal provision and Hindu marriage. Hindu marriage is here. "19 and 20. 28, huh? Right, come to 20. "19. I'll take it up, huh? Hindu marriage act, you read it and come. There is nothing.
Yes, I will satisfy, my lord.
Immediately after. Yes. It will be there on the board. We'll take it up. Yes, sir. Which is your matter?
Section $15.
15, yes, 15.
Section 15 is.
He will read it. 15, 19, 28, everything you read.
Yes. Section 15 clear.
Very clear.
Item 101, my lord. It is that case where I have challenged, my lord, the initiation of the action by the ED, despite, and your lordship had also passed an order at an interim stage. Now it is for final disposal. And they have filed ED has filed an objection to my application, my lord. I received the copy last week. I also want to have my own response.
Urgent to some of the day, interim order to continue.
My lord.
Sorry, my lord. Let you take it tomorrow, my lord. Because in court number 2, I have also passed over, my lord.
Tomorrow.
Tomorrow.
Last. Read it.
Yes, yes.
Section 15, 19 and 28. You read and GC interpolation.
Section 15 टा पूरा clear कर दीजिए.
पूरा clear. पढ़ दो ना दिए.
ना मुझे satisfy करेगी कि during the.
पढ़ दो, but that's the.
For his satisfaction. I was very similar.
And ultimately.
Section 15. When a marriage has been dissolved by a decree of divorce, and either there is no right of appeal against the decree, or if there is such a right of appeal, the time for appealing has expired without an appeal have been presented, or an appeal has been presented but has been dismissed. It has be lawful for either party to the marriage to marry again. Very clear.
You tell me the date of preference
Yes,
of
yes,
the
yes.
appeal. We'll see. 100, just let me.
124.
1 minute. 130.
Last three matters.
Last 3 minutes. Take it out. 131, huh? 131, huh? What is this matter about? Just. Yes. Yes.
And that has already been decided in 25 cases, which is the command that has been passed by this honorable court. And it is covered by this.
Which paragraph of this judgment?
Last one.
Huh?
There are raised that has been decided. uh,
34. Yes.
28 is the discussion of 20, paragraph 20. In view of the same, I am unable to agree with the assumption that it is sought amendment to the special judge under the PCR has been rendered with the power of confiscation and the object of the term. Thereafter, it is directed of the notification to deal with confiscation directed under the provision of the Special Court Act. Hence, refusal of the authorized officer by the insurance order to drop the proceeding cannot become fault on this said ground. Though this court is not in agreement with the ground action of the authorized officer, that the aperture enhancement has been formed into court after the initiation of the confiscation proceeding has no application to the proceeding initiated prior to the said amendment. This is the retrospective measure. So far as the aperture review, this court is of the belief that all criminal office challenging for the order refusing to drop the confiscation proceeding on the ground as the rate that is recognized. Between two enactments, the reward of the stands this.
Let us see then. Let us see 31. What have you challenged here? 31. Appeal, huh? Where is the order of confiscation? Confiscation order?
Page number
13.
13, Annexure 2.
Yes.
Annexure.
No.
What is the petition?
Annexure 3. Advocates for the party that present the case of prosecution of further examination of the court on the behalf of resolution number 2 and 4. Is also present in the court. The government council of the state resolution has filed a petition of signing on the ground of resolution on the order and the government council of the resolution number 1 has filed a petition with the prayer to drop the present proceeding on the grounds stated therein. Officers the government, and it is stated in the petition that Orissa Special Court Act 2006 is repugnant to the provision of the Prevention of Corruption Act 1988 and the Criminal Law Amendment Ordinance 1944. In the meanwhile, the Prevention of Corruption Act 1988 has undergone various amendments by virtue of the Prevention of Corruption Amendment Act 2018, which received the presidential assent on 26/7/2018 and became effective since then. By virtue of the said amendment, a new chapter by chapter 4A containing section 18A has been incorporated with which relates to attachment and forfeiture of property. It is further stated in the said section that the provision of a Criminal Law Amendment Ordinance 1944 is to be made applicable for attachment and forfeiture of property involved in the offence, and the forum of such attachment and forfeiture is the court of the special judge appointed under Prevention of Corruption Act 1988. Since the power for forfeiture of the attached property has been vested with the special judge vigilance, hence this forum has no jurisdiction for confiscation of the alleged disproportionate assets as per the provision of Odisha Special Courts Act 2006. It is further stated that even in case falling under Article 254(2) of Constitution of India, where the state law prevails, such law could not be amended, varied or repealed by Parliament by enacting law subsequently, both by virtue of Clause 1 of Proviso to Clause 2 of Article 254 of the Constitution of India, where the Central Legislature passes an act on the same subject
within the meaning of proviso to clause 2 of Article 254, the state law, which was at variance with it, is rendered bad for repugnancy, although such state law and
I understood it.
yes, my lord.
What about the other matter?
Other same, my lord. Same order.
Same order.
All the three 131, 32, 33,
Yes.
same order.
131, 32, 33. दे देना order कर दो. ठीक है. Expose आप हाँ.
Yes. Obliged. And
Three matters have three.
120 after that.
124.
130
Yes,
after
ma'am.
vacation.
124 matters in the record the appearances.
And my lord, 130 seta after vacation as well.
130.
Seta A related no. Vigilance. Seta
Let it be there on the board. This
Yes.
is again 17.
Yes.
This
No,
is
no.
17.
17 appeal, but it is not in the same issue.
Okay.
What happened? You already shared the proceedings, which you noticed to the other side. And I have shown that for the all commission. So on the basis of compromise, I have read affidavit.
Where is Sanjit?
Informant.
Sanjit
Yes,
Ranjan.
madam. He is present.
Present, my lord. And Krishna Tiwari.
Yes, madam. And so also I also shown an affidavit of the injured also for those commission.
Where is the injured?
Injured is also there. I have shown an affidavit for those.
Just see the injury.
Madam?
Just see the injury.
Affidavit
Affidavit क्यों तो?
The decision was taken. I have already served the copy.
नहीं नहीं अरे इंजुरी तो कौन है जी इंजुरी रिपोर्ट कौन तो injury my lord simple in nature my lord where is that give it file that certificate copy and what are the offenses
307 along with other offenses.
307 right at the instance the accused persons my lord all are there just check it up Mr. Maharaja injured
It is mentioned that 1 and 6 others. 1 and 6 others. So 1 to 5 are there.
petitioner file 4 person 4 people quad is petitioner will quash it
4.
quad is petitioner will right down at the instance of who is the informant
Informant
injured is Krishna informant is Sanjit right up. At the instance of opposite party number 2 FIR number so came to be registered against the petitioner a petitioner under section so charge sheet file no
no my lord charge
give that certificate copy
sign kari attest kariye.
charge sheet file not file
No, investigation on.
the investigation in the present case is still on the very simple injury middle what does it say simple column where did it say simple
Injured is not the party, my lord.
not party my lord file affidavit Mahendra Singh
no, injury you said Krishna Tiwari is the injured
Krishna
why are you trying to make wrong
victim my lord
Injured is Mahendra Singh
Krishna Tiwari my lord
and
victim
Krishna Tiwari.
Krishna Tiwari is there where is
Victim.
Mahendra
Krishna Tiwari is one. Who is
Victim.
Krishna Tiwari? Yes.
where is Mahendra
Mahendra is not there. He also has not been made as a party to this proceeding.
what is the injury caused to Mahendra
last occasion my lord in the time of interim order my lord High Court directed to file
there are
party,
two
my lord.
there are two injured here 307 is
Yes, ma'am.
is alleged against you both the injured has you have to see both the injured received what kind of injuries
They should have made as a party at least. Because unless something they are present in the
my lord yes my lord already copy my lord both copy my lord
and where is Mahendra's affidavit
Mahendra affidavit.
Simple my lord
Mahindra affidavit kind. Mahindra Pratap has filed it.
Last, my lord.
But he is not there.
Party କରନ୍ତୁ petition ରେ party କରନ୍ତୁ petition is not
ସେଇଟା ପାର୍ଟି କୁ ହିଁ କହିଥିଲେ ସେ ପାର୍ଟି ହେଇ
opposite party number
lawsuit directed to at a party
Is very
this issue but not added in petition, my lord.
simple है. Mahindra.
Both, my lord, in victim and injured, my lord.
Where is it written simple?
Simple in column, my lord. Left, right side, my lord. Simple.
Simple.
And, yes, my lord. And another, my lord.
This is
Name, my lord.
Krishna Tiwari.
Above.
This is Krishna Tiwari. Where
Yes,
is
my lord, Krishna Tiwari.
Where is Mahindra?
Mahindra, my lord. Another page, my lord. Right side, my lord, in column.
I am having the injury report. That is simple.
Yes.
I am reading my lord on page of
Mahindra.
injury.
Simple.
There are two injuries. One is face swelling, foot strain, which are simple nature, caused by trauma. On injury report of Krishna Tiwari, the face bleeding from left nose and swelling at bridge of nose, which is simple nature, caused by blunt touching.
Right. Additions of opposite particular na. Investigation in the present case is taken on. Next paragraph. The medical examination report collected, medical examination certified copy of medical examination report has been filed by the petitioner, which are taken on record. Which indicates that the injury received by two injured, namely Krishna Tiwari and Mahindra Singh, are simple in nature. Simple in nature. The opposite party number 1 is the informant, and opposite party number 2, one of the injured is present in the court. The injured number 2, namely Mahindra Pratap, has not been included in the present case. However, he has filed an affidavit being attested by the he has filed an affidavit inter alia stating that he has settled the dispute to the accused person. Next paragraph. The petitioners are present in the court. There are 4, although in the FIR there are 6 accused persons. There are 6 accused names are there. 7 accused.
6 others. One local na then 6 others.
Right.
So total 7.
Although in the FIR, one accused person name is written, and it is alleged that
Hima and 6 others.
Other 6 persons are also involved in the present case. However, the present petition is filed by the 4 petitioners only. And next paragraph. The petitioner, all the 4 petitioners and opposite party number 2 and 3 are present in the court, being represented by their counsel and identified by them, and filed the separate copy, which is taken on the court. The party stated to have settled the dispute, and the informant and the injured number 1, namely both the injured and the informant have filed a separate affidavit dated 24/8/2023, inter alia stating that they have settled the dispute. There is no grievance left. There is no grievance left to be addressed. Against the petitioners. Mr. Maharaja appears for the state and submits that although 307 IPC is alleged against offense under 307 IPC is alleged against the petitioners. However, the medical record indicates that the injuries are simple in nature. The petitioners have settled their dispute with the victim and informant. All of them have filed the affidavit to that effect. Therefore, there is no legal impediment to personally taking into consideration the settled principle of law, taking into consideration the principle of the Supreme Court in Jansi and Joshi, and evaluating the factual and of the considered opinion that subjecting the petitioner to trials would be a federal exercise. Therefore, the petition deserves merit. Accordingly, also 21st, for the petitioners, subject to the petitioners paying 1,000 rupees each to each of the victims, 1,000 rupees each, subjecting petitioner to pay 1,000 rupees each to each of the injured within during the course of the day by within 2 days. Within 2 days and filing the receipt of the same before this court. 40,000. Find the receipt, then only it will be uploaded. Yes. Yes.
Course of the day, man. Course of the day.
During the course of the court. Hmm.
48 under section 483, 48, surplus 3 CRPC general challenge, my lord.
For
Glance to page 36. I am the complainant before the court below. I filed a complaint against the respondent. Offense under 138 and Act. He was convicted and for RI for 1 year and fined of rupees 7,000. Assailing the same, his preferred appeal before the London District Judge Nuapada. Appeal is pending. During pendency of the appeal, I filed a petition 148 CRPC of the NI Act that are turned down at page 36.
Turned down?
Yes, page 36.
Turned down.
Dated 28/2/2024.
You are the informant, huh?
I am the complainant. 138.
The petitioner is the complainant in a case under section 138 NI launched by him against the petitioner.
Against the respondent.
Against the respondent. By the order dated, which order convicted?
Page 36, my lord. 28/2/2024. Page 36.
Tell me the date, sir.
Date is 28/2/2026, my lord.
By the order dated
2024.
2024, or the which court?
Session Judge Nuapada, my lord.
No. Conviction.
SDGM Nuapada.
Where is that order?
Yes, I am coming to that. Your lordship, see at
Madam, by the order dated, by the order dated 4/9/2023, the SDJM Nuapada,
page 25, para 13.
Nuapada in ICC case number 2 of 2021 have recorded conviction against the respondent and awarded various awarded sentence.
Page 25, para 13. Arrive for 1 year and fine of rupees 7 lakhs.
Fine of rupees 7 lakhs. The respondent preferred an appeal before the Court of Sessions Nuapada. While the appeal was pending, the petitioner moved an application under section 148
3 CR of the NI Act.
NI, which has been turned down by the court by the impugn order. Issue notice to the opposite party.
The info needs to be noticed, madam. Info needs to be noticed. The other side is to be noticed.
Yes, I have issued notice. What do you want?
The other needs to be 143.
What do you want? I have issued notice. I can't say what will you
without
get
the other
out of the his appeal, let it go.
Because you also see 143A of the NI Act that towards interim compensation.
I know, I have issued notice. I know they can be passed.
Yes. May I pay for one thing, my lord? Of course, I have not filed any IF for stay. You also see the last case is posted to this month. It was posted to 6/3. Then tomorrow it is posted. May I say that on filing a time petition on a trial, appellate court will do well to adjourn the case.
Submit that you would be moving appropriate application for seeking adjournment for the court below. The same shall be considered. Owing to the fact that the matrix evidence will come.
Yes. Fixes are written before vacation.
Yes.
49.
Annexure 2 is the impugned order dated 27/2/2024. On that day, the enrollment is sued against the present petition also.
You are on bail?
Yes, your lordship. That is Annexure 1. 18/5/2023.
18/5?
2023.
18/5/23.
Is enlarged on bail.
He was on bail. NBW issued on 27/2/2024.
Yes, your lord.
24. Oh, 500. Yes. Item 50.
50 years, my lordship. The NBW was issued on 1st July 2023. Petition was enlarged on bail 6/4/2022, your lordship.
6/4/2024. 24.
22, your lordship.
22. 6/4/2022. NBW 17.
2023, your lordship.
500. Yes. 51.
51 may I take notice? Lord, in this case, I have challenged the cognizance order dated my lord 10/2/2022. My lord, on the ground of my lord, if my lord may come to running page number 38.
Tell me what is that?
My lord, cognizance has been taken on the offense of my lord 153A, 143, 149, my lord. When the section 196 talks about, if my lord may permit me to this section 196 of CRPC, my lord.
Yes.
It says, my lord, prosecution for offences against the state and for criminal conspiracy to commit such offence. No court shall take cognizance of any offence punishable under chapter 6 or under section 153A, section 295A, or section 1 of the of section 505 of IPC. My lord, I fall under 153A.
Yes.
My lord, except with the previous sanction. If except with the previous sanction of the central government or of the state. My lord, the court has rightly struck off section 188 as per 195 and did not take any cognizance of offense under section 188. But my lord, simultaneously had taken cognizance under section 153A when my lord, section 196 bars cognizance without a valid sanction. My lord.
Yes, Mr. Maharaj.
My lord.
Second, what they actually 153A.
My lord. 153A.
153A. There is bar.
There is a bar, my lord.
What to do?
Let us know. Issue notice.
No.
Take instruction.
Issue notice. Take.
My lord, no, state is the only party, my lord. I'll serve extra copy, my lord.
Shall I pause that part?
Only that offense will be paused and
my lord,
the rest party will proceed.
I allow.
Yes, sir.
Why to keep it pending?
Why, sir? Unnecessarily
my lord, may fix up any date so that I can.
Why pending? I am allowed your petition on it.
My lord, cognizance order may be passed.
Is statutory power?
My lord, if
you can't have both. Your only ground is that provision is not retracted. I'll cause it.
That provision is not applicable.
Petitioner is challenging the order dated 10/2/2022, passed by the SDGM Jagat Singhpur in
my lord, GR case number 1373 of
2022, whereby the court below has taken cognizance. Where is that? Cognizance of offenses under section 153 capital A oblique 143 oblique 149 IPC.
Yes, ma'am.
IPC. Okay. Mr. Mahapatra, land counsel for the petitioner submits that taking up cognizance under section 153 capital A is barred and by under the provisions of section 196
1A
1 capital A
small a
small a of CRPC which reads as under 196 small a. Mr. Maharaja, land counsel for the respondent submits that indeed the trial court has the order of cognizance insofar as offence under section 153 capital A is concerned is not sustainable, whereas the offences under 143 and 149 taken by the SDGM by the interim order is no illegality could be found for the offense for the illegality would be found in the cognizance order, taking the cognizance of offense under section 143 and public 149 IPC. Yes. IPC. Taking into consideration the provision of law cited by the legal counsel of the petitioner, I am of the considered view that the cognizance order which the offense under section 153 capital A could not have been taken in view of the bar containing under section 196 a small a of CRPC.
1A.
Accordingly, the said of the cognizance order vis-a-vis offense under section 153 capital A is quashed insofar as the offense so far as the cognizance order under section 143 and 149 is concerned, this court is not inclined to interfere.
At this stage, my lord.
Not inclined to
Proceeding against him.
at this stage, trial could proceed
Because, my
in
lord,
accordance with law.
So far the offense, other
so far-
offenses are concerned.
So insofar as the offense, other offenses are concerned.
Yes.
My lord, at this stage, because I have not gone to the merits of the case.
Next.
Obliged, my lord.
52. Meet it with yours. Here, my lord, I have filed this application against the rejection order passed by the learned vigilance.
Dated 11.
My lord,
You want
my lord, on
5.
my lord, it is a peculiar case. On 5/4/2004, P-5, the IO was examined. On the same day, my lord, I have glanced over running page 23 of my petition. I have annexed the order. Due to illness, there is a prayer that it may be adjourned to next. But the same was also rejected. And thereafter, on 6/4/2024, I filed an application under section 311 to recall P-5 for cross-examination because he has not at all cross-examined.
Where is his examination?
My lord, on 4/5/2005.
Where is that?
My lord, I have
Statement.
my lord. I'm sorry, I have not pinned it, but it is
How?
Lordship, kindly see page 22.
22.
Last paragraph.
Yes. Let counsel for the
No. Thereafter, court requested to learn counsel to the cross-examination to the IU. The all along
Para 22.
page
22. Order dated 5/4/2024.
My lord.
Yes.
Thereafter, the last para.
Hmm.
Thereafter, the court, all along the counsel was present during cross-examination. And thereafter, the court requested the learned counsel to cross-examine the IU. Because it is very difficult, much difficult to get the attendance of the witnesses like IU and TLO through VC. But in spite of request of the court, the learned defense counsel, though present in the court, they refused to cross-examine and preferred to decline the IU. Accordingly, he was discharged. Thereafter, he filed a petition on the ground of illness. He was all along present.
After the court requested the learned counsel to the proclamation, what is TLO?
TLO? Trap-laying officer. Trap-laying officer.
He has examined only IO.
But this can't be a ground.
No, once he
Convenience of a witness is not ground. His right as an accused is has to be,
he was all along during examination, he was there. So far as PC Act is concerned, it should be conducted day-to-day basis. So he was all along present during examination, and he himself refused to cross-examine.
5/4/2024.
My lord.
And when he moved the application?
My lord, on the same day, my lord.
On the ground of
Perhaps my
illness.
lord, blood and has not gone through the petition. Petition was filed on the same day.
No.
Latter next part.
Latter part on the same
Latter,
day.
learned counsel for the accused, Lambadar Behra, filed a time petition for adjournment of the cross-examined
Running
PW
page 23, my lord.
Conducting lawyer is ill. But he was there. On his version, the case was
20.
next page. I don't know, because he has not cross-examined.
My lord.
Se Jama cross-examine karna.
Not started, my lord. Due to illness, it was not, he was not.
Who is this? IO?
IO, my lord.
IO.
Give one opportunity.
My lord.
Right.
I should not say object also.
The petitioner is agreed by the order dated 5/4/2024, whereby his application under section 311 CRPC has been rejected. it is contended by the petitioner that the petitioner has moved an application under section 311 CRPC seeking to cross-examine PW 5, PW 5, comma the IO of the case. When the IO was being examined, the IO is being examined on 24, the petitioner could not cross-examine the witness as his counsel was ill. On the same day, he moved an application. Application seeking recall of the said witness. Witness.
No, my lord. On the same day, it was not filed for recall to defer the cross-examination. On the next day,
Same day, he moved an application seeking an adjournment
My
of this
lord.
matter and adjournment matter.
my lord.
Subsequently, thereafter, he moved an application under section 311 CRPC, which has been turned down by the impugn order. The fact germinating from record indicates that the petitioner has indeed not afforded any opportunity to cross-examine the cross-examine PW 5, who is the vital witness in this present case. Therefore, he deserves an opportunity to cross-examine the said witness. Accordingly,
the records or something different.
accordingly, the impugn order is set aside. Impugn order is set aside, and petitioner is
Conscience.
directed the sessions court, district
Yes.
additional district sessions court, come special judges with
Vigilance
Anukul
ongoing.
is directed to afford one single opportunity to the petitioner to cross-examine PW 5. PW 5. It is made clear that no adjournment shall be granted to the petitioner on any ground whatsoever. On the petitioner has to conclude the cross-examination on the date fixed by the
Only on that. And my lord, the copy may be supplied in post because it is kept for judgment within few.
Copy there.
My lord, obliged. The copy is check for it.
53.
Yes.
Here मला one CC case तम कौन करी copy. You proceeding under sir 130 of NI Act notes. I faced the
accused.
Yes, I faced the trial. Then got conviction. After conviction, I filed an appeal before the appellate authority.
Right.
Including application also 389 of charges to bail. Page 46 lordship of the brief. The appellate authority granted me bail orders. And during course of granting bail, taking into consideration 148 of NIR, impose condition 20% of the compensation amount.
Rightly. What is
So
wrong?
I submission made submission there. One decision, this is not mandatory. The 20% amount is not mandatory. Rather, that should be considered.
No application there. What 482 code will do?
You know, so that observation I can file an application again for the appellate authority for consideration of the such.
The petitioner is agreed by the order dated 29/3/2024, passed by Lieutenant Sessions Judge Mayurbhanch in criminal appeal number 10 of 2024. The petitioner was convicted for offence under section 138 NI Act. By order dated. By order dated 1/3/2024, passed by the JMFC.
Bethnoti. Bethnoti 1631
Bethnoti.
Yes, ma'am.
In ICC case number 31 of 2021. He preferred the appeal against the said conviction and sentence order.
Appeal admitted, but so far the bail is condition.
Preferred the appeal against the said conviction order. The appeal, although the appeal was admitted, but the petitioner was directed to deposit 20% of the awarded amount. 20% of the what amount? 20% of which amount?
2,40,000.
Where is that?
Page 46, Your Lordship. 2,80,000, 14 lakh or 2,80,000.
No, impure order. Trial court order.
This is page 36, Your Lordship.
Maybe 20% of the fine amount. In compliance with section, in compliance with the as per the mandate of section 148 capital A of NIS. Then Counsel for the petitioner submits that the 20 direction of 20% deposit of 20%, direction of direction to deposit 20% of the fine amount is not mandatory. It can
That is too harsh.
it is not mandatory, and owing to his precarious financial condition, he is not in a position to make good the payment. Therefore, he says in this hard condition of deposit of 20% may be waived, or varied. I am not inclined to entertain this petition at this stage. However, I gave liberty to the petitioner to move appropriate application before the court below for seeking variation. Appellate court, before appellate court, seeking variation of the impure order, highlighting his financial constraints, and if such application is moved, the same shall be considered on its own merit, keeping in mind the financial constraints and many subjects.
And team so there shall be no course action because I have been directed to APR people.
No, don't ask that. I should have dismissed right away. 148 is mandatory, you have to pay 20%. Still, I say that financial condition, you go and approach this much indulgence, no further. Yes, next. Pass over. 54?
43.
43?
54.
54. कौन आ रहा है?
Then although your lordship, I challenge the order of cognizance, but I pray your lordship in the meanwhile the co-accused persons all have been illegal bail against whom there is allegations of us. And against us we are only allegations of unlawful assembly. I pray your lordship send a dismissal Parity.
Who are the co-accused persons?
That is your lordship, the unnecessary 5 series, page 33 to 39. Page 33.
All co-accused persons are granted bail.
Yes, ma'am.
You will get parity. What is the problem?
But I observation of it same day.
But
that's clear also.
You will go and apply. The petitioner is challenging the order in this petition. Petitioner has challenged the order dated 30/11/2020 passed by the learned HCM Aligarh in city case number 324 of 2020, whereby cognizance for offence under section where is that? Cognizance for offence under section 341/344/294/326/307/302/34 IPC has been taken. IPC has been taken against the petitioner and how many petitioner and who are you? What is your name?
My name is
Petitioner and 4 other accused persons. 4 other accused persons. The petitioner, the counsel of the petitioner submits that in so far the other co-accused persons are concerned, they have already been granted bail by this court by various orders. He has filed. He has filed by through annexure 5 series. He submits that he is entitled to the parity while granted bail. Although he has challenged the cognizance order, but although the counsel petitioner has challenged the cognizance order, but the counsel for the petitioner submits that he would appear before the court below and move the appropriate application for grant of bail on the ground of parity, as other co-accused persons have already been enlarged on bail. On instructional petition, submit that he would appear before the court on or before 30th of May, 30th of May 2024, and move appropriate applications under law, and take under law. He may, needless to say that all the ground available to him, including the ground of parity, may be taken by the petitioner while pressing for bail, and the Gallant court below. Then court below shall consider the application in accordance with law.
The same day dismiss both the questions.
In accordance.
Yes,
Not
because I
this much 302. Why should you unnecessary?
Eligible also having no power to consider my bail application. Only it is sessions also.
Yes, on the same day.
Same day.
On the same day. Next.
I connected 87 years.
87 also.
Connected.
Another accused.
For total 4 accused person, 2 was eligible by this one court, another 2 years by this application.
87 which I got.
87 same.
Same court. Yes.
Item 10.
Disclose that one. Yes, 10. Yes.
I am challenging the answer page number 17, Lordship. In this case, the NBW has been issued against the petitioner on dated 31st October 2016.
In the prayer, you have written dash. What order?
Yes.
This the prayer.
But in this case, alleged offenses.
It's all right. Which is the date the NBW was issued? You have written date dot. What? How?
Let's say 31.
31.
31/10/2016.
You are on bail?
No, Lordship. Except the this petitioner, all the accused persons has been released on bail, Lordship. By the APL number.
NBW was issued against you.
Yes, Lordship.
You are shown absconder.
Yes, Lordship.
And IO has requested for issuing NBW. Huh?
Yes, Lordship.
Where is that order? Where is that order? Where is it?
The order is not to arrest, Lordship. Lordship, this is
where is the order by which NBW was issued?
Lordship, Annex 3, page number 17. Lordship.
Item 10 you are talking about?
Yes, Lordship.
Where is the annexure 3? Annexure 3 is not there. There are 2 annexures.
This is the Annexure 3, page number 17.
17. Only original file though. Yeah. It is only annexure 2 only there. Let's see. Huh? It should be there in our record, not that record. He has not filed the annexure 3. He has not given the date of order. What is this?
Initially, when I have filed this case, I have not filed the impugned order, Lordship. Subsequently, in the SR, defect already shown, then I have filed.
Where is that? Has he filed? Just see. Why are you wasting time here?
No.
SR reported, huh?
SR reported. No, SR reported.
Not cured.
Page 17. Huh? Page 17 as per index not filed.
Not filed.
Crossed actually.
And you have not given date also.
Subsequent.
You have not filed it. Where have you filed?
So I filed the copy, Lordship.
Actually, not.
No,
I'll go to you. Huh?
Afterwards.
Right. Okay. You are shown as absconder in the charge sheet?
Yes, Lordship.
Right. Petition is accused in FIR number so. The charge after investigation charge sheet was filed on 9/8/2015, showing the petitioner as an absconder. Absconder. Therefore, the court of JMFC Banpur, wide order dated 31/10/2016, has issued NBW against the petitioner. Against the petitioner. On certain petitioner, counsel for the petition submits that the petitioner would appear before the court on or before 30th of May 2024 and seek remedy available to him under law. Subject to petitioner appearing before the court on or before also the NBW issued on 83C those of solo by JMFC Banapur in GR case number 207 bracket capital A oblique 50 2015 is operation of no. Yes.
18.
Last particular lordship directed instruction with regard to annexure 2. Offense which is 6. 9 of Conduct of Examination Act. A punishment is for 6 months.
Another time may be given since the case is 96 year of 96 my lord, they were searching the record my lord in the police station.
My lord's order.
Today my friend contacted them my lord.
42 page 42
96
page 96 6 months maximum punishment. What abscond? I'm an employee, sir. You are the employee. Your lordship may see that page 40. Page 40.
Where are you?
I
would let Asu.
Your lordship may see.
Yes.
42. Sri BP Das, the principal of the BJP college. Sri R.K. Naik, the assistant controller of examination of the council. Sri Muralidhar Singh, the present petitioner. And Sri Sarveshwar Samal. These 2 petitioners are before your lordship. A senior assistant of the council are made accused in the criminal case. On a consideration of material placed on record, the committee finds that there are not involved either directly or indirectly. In the linkage of cocaine. Yes.
Charge sheet not filed.
Charge sheet do na, charge sheet ami dekho
Your lordship, that is the order of the.
I am asking, charge sheet is filed or not?
Yes, my lord. Charge sheet filed, cognizance taken.
Where is that charge sheet?
Lordship, Annex 3.
Where is the charge sheet?
Yes, my lord. Charge sheet, but cognizance taken. Your lordship.
Charge sheet देवे ना.
Charge sheet हिला बोलते cognizance नहीं आला.
सेटा तो ठीक है, charge sheet दियो तो ना.
Charge sheet रे कौन है?
और जो charge sheet हिमाने देवे ना हमें. हमें तो कुछ ये कर लिए.
I understand you have a fantastic case, but
your lordship last occasion.
I know that. I know that no case is.
They able to obtain the cognizance order. And they can validate file the charge sheet valid.
Man, do the inquiry report. Commission बसेले. Headed by my lord justice.
I wanted to know. 96 रे cognizance नहीं आई थी.
My lord.
तो बर्तन जे कौन आ रहा?
सरनियम पड़ी थी सर. किच्छु होनी.
4 सौ फेम ହେଲା कि नहीं?
कोपरेट करनो तो किसी को ना आसो थे बोले.
ଆମ କି କଣ ଆମେ ଦିଟା କିରାନି.
ଆପଣ ତ ଏକୁ ଜାଣିଥିବେ ନା କଣ ହେଇଛି? You are not participating.
କୋର୍ଟରେ କିଛି ହଉନି ସାର୍.
କିଛି ହଉନି. ମାନେ in 2024 we come up and we are saying that we
अरे हम यार तो किसी नहीं है. Maybe quite 6 months punishment.
Enter order sheet आना तो charge sheet दे.
Maximum punishment is
1 minute later. You get instruction next week I am putting it. If it is 96 case, which may be closed also. Therefore.
And we don't know. Lordship have taken the view only over the commission report. My lord justice.
I know.
That way.
I remember. Wait, let us understand.
Yes.
पता है बाकी separate डिग्री conviction डिग्री आपकी गोलनी पड़े.
हाँ जितने देखिए बड़े.
Yeah, lordship can consider for the moment the document which are in their favor. They are showing that paper. They could able to get that document, but they are not able to get the charge sheet copy. That your lordship knows.
And order sheet and yes,
just I wanted to know whether the trial has already been concluded for the other. But देखी दो ना 96.
Let them take instruction.
Absconder.
At last answer. अरे हमें कहीं absconder.
Next week.
हमारे कोड़ी.
Next week रखो जाएंगे.
May I pray one more, Miller? Since the case is pending before the learned court below,
I will seek a report from the court.
Yes. That I want.
Where is that item? Yeah, na. The learned counsel for the 1 minute. Where is that? What code देखे लगे सेटा?
Code cognizance
order था इटा?
हाँ 872 of 96.
Yes. Mr. Man Singh, learned counsel for the petitioner, submits that although in the present case cognizance of the offence under section 9 of Orissa Conduct of Examination Act 1988 has been taken way on what 1996, but the trial has not yet been commenced, and the trial has not yet been commenced. The co-court pending achi
SDGM
Bhubaneswar
in GR case number
is directed to submit a report by next date of hearing regarding the status of GR case number 872 of 1996.
Right. Right.
पूरा clear जଣା पड़ जाएगा।
भाई जଣା पड़ जो कौन लगा
And also
copies of the matter.
In the meantime, Mr. Man Singh is directed to place on record the copy of the charge sheet.
Yes.
Actually, because police people have submitted the charge.
Why are you waiting? Why are you? Do you have our copy or not?
Nahi sir, film they can give it.
Mr. Ragda may call for the CD in the present case to assist the court in the next,
including charge sheet.
CD also.
Yes.
Item 20.
Here I am challenging the order of cognizance dated 13/9 of 2022, passed by the additional district and session judge, cum special judge Fulmani, taking cognizance under section 20B 2C
Yes.
and 27 NDPS Act, your lordship. Here, my lord, the petition is implicated on the basis of the co-accused person only, your lordship. Meanwhile, the co-accused person has been already acquitted by the trial court, your lordship.
Where is that chat? You are absconding.
My lord.
Page 17, my lord.
I was not present at the spot, your lordship.
Oh, the same thing.
My lord.
Page 17, my lord. Judgment, my lord.
The
Paragraph 17.
examination report is not.
My lord, chemical evidence not produced, my lord. In fact, my lord, I got instruction, my lord. Though from whom you under the custody the ganja has recovered, my lord, 9 bags, my lord. One bag containing 40 kg, my lord. Total 432 kg ganja. And that after, my lord, in the meantime,
Chemical examination report is not.
for that ground, he has been acquitted and mandatory provision are not
Search
complied.
procedure also not
And
complied, your lordship.
that in the meantime, what happened, my lord? Here, my lord, one of the co-accused acquitted, my lord, from whose custody that has ganja has been recovered, my lord, and he confessed before the police that these persons fled away from this spot. That is the allegation, my lord. In fact, my lord, in the meantime, what happened during pendency of this criminal miscase, my lord, 2 of the co-accused persons, 1 and 2, 1 and 3, they have been arrested, my lord. And 3 not arrested, my lord. And imbue issued, my lord, prior to submission of charge sheet, my lord. On the prayer of the IO, my lord.
What happened to the other accused persons there?
1 accused acquitted, my lord. 3, my lord.
Main accused is acquitted.
Acquitted, my lord.
What about the other people, those who are apprehended subsequently?
Subsequently, 2 persons, my lord, here from this court, 2 persons, my lord. Another accused apprehended, he has been granted well by the court. So far, my instructions is concerned, my lord. And in fact, my lord, here, my lord, 2 persons in behind the bar, my lord. One is at large, my lord.
What is happening to their trial?
Trial, my lord.
They must be facing trial.
Not been commenced.
But they're missing. They must be
Co-accused acquitted. Others, my lord, they have been arrested, my lord, during pendency of this month, my lord, perhaps, my lord.
Bastard Corner, my lord, one of the Bastard
20 February.
You get instruction, I'm issuing notice.
My lord, Bastard Corner concerned, your lordship, have filed the anticipatory bail, have got the interim order by this honorable court, but despite that, they have arrested Bastard Corner, the meanwhile.
2 of them, my lord.
Bastard Corner and Raidhar.
Despite anticipatory bail, they are arrested.
My lord.
How can they arrest like this?
No, my lord, that is not there, my lord. Though interim order granted them a certain period, my lord, and that has not been extended. For that, they have been arrested.
Which you notice, lord. There are total how many accused?
My lord, total, my lord.
Here there are 3.
Total,
one accused is acquitted.
6.
What about the other?
1 accused acquitted.
Out the 2?
3. Arrested bail ଯାଇଛନ୍ତି ଆଉ ଜଣଙ୍କର arrest ହେଇନାହାନ୍ତି.
You give me the real status. Give me the detail. I am issuing notice. There are 6 accused. 3 of you are here. 1 is acquitted. What about the other people?
Other people are absconding, your lordship. They have not been arrested.
I am just issuing notice. Because only I am issuing notice because chemical analysis report is not there. Even if you are put to trial, you will be acquitted.
And my lord, the mandatory provision of the search and seizure have also not been followed.
That's all right. You are extending that. Get first next week. Next week.
Next week.
Before
Next week,
vacation,
Your Lordship.
further. ठीक है? Yes.
38.
Obliged.
38.
2004 affair. Compromise has been made. Lordship, both the legal heads of the informant had appeared before the Lordship last occasion. Their personal appearance also dispensed with by your Lordship. Their affidavits are on the record.
Additional documents to substance.
What are the additional documents that is
Additional affidavit filed by the OP2 and 3, the legal health of the informant. Prior to death, my lord, he made a compromise on Annex 2, my lord. Ultimately, Annex 2.
Rafanama.
Family dispute.
Rafanama, that I know. I recorded everything in my
and
order.
that has been corroborated by the legal
Yes,
health.
Mr. Rahul, what do you say? See, what had happened in this case is, this is a 306
committed
306 case.
Yes, my lord.
The informant has entered into a settlement and signed a Rafanama. And thereafter, he died. Now the LRs have come on record.
Yes, my lord.
They've also come here and they are moving. They file affidavit stating that we have settled the dispute.
Legally
What do you want to say?
My lord,
Nothing. 20 years ago.
Incident is of
2007.
2004. 2004. We are in 2024.
after Rafanman,
Nothing.
the deceased.
This is the informant has filed the Rafanama, and that was supported by his legal help.
Was it?
Yes.
Yes.
20 years ago. Madam, the matter was taken up for hearing on 16/4/2024, and this court passed the following order. Not a copy, huh? Give me the affidavit. No. What are the additional documents you wanted to file?
Affidavit, next legal affidavit.
Persons to the aforementioned order. Mr. Mansingh has now filed.
Already filed. Already filed. That is on record.
That time it was there already.
Subsequently, it was filed.
Yes,
Lordship, my lord's record is original.
Let's see. Then last date of hearing, I said that Mr. Mansingh, counsel for the petitioner, also seeks time to place on record additional document to substantiate each case. What are the additional document I am talking about?
Your lordship, with affidavit, because they have not filed that affidavit before coming to your lordship. Without affidavit, they have come. That I have submitted, they will file it.
But this affidavit was filed on the same day. Because
same day afterward, they have appeared before your lordship. That old lady lordship may remember.
Right.
That have made the affidavit before the commission.
19th.
Yes.
Is there any, in the last order, is there anything regarding affidavit? No, last time affidavit was not filed. Right. Persons to the.
Yes, my lord, your lordship was directed to them and dispense the personal appearance and directed to, yes, my lord.
Persons to the aforementioned order. On the same day, the opposite party number 2 and 3. Isn't it? Yes. Opposite party number 2 and opposite party number 3 have filed affidavit before this court, inter alia, stating that the matter has already been settled by their father. Yes. By their father, who was the informant in the present case.
Father of OP3, husband of OP.
With the petitioner accused. After the Rafanama was signed by the Rafanama dated 15/1/2016, signed by the father of the present deponents. Deponent, their father has expired on 13/2/2017. Therefore, the present opposite parties are made party. Opposite parties are included as a respondent in the present case. In the affidavit, they have also stated that they don't want to proceed against the petitioner anymore. In the anymore. Next one, Mr. Rahul also appears for the state and submits that the FIR was registered way back in 2004. By now, 24 years, 20 years have already been passed. The original informant in the present case has already expired. Before his death, he had already entered into a settlement with the petitioner. Thereafter, the LRs of the original informant have also approached appeared before this court and filed the affidavits stating that they don't want to proceed with the case against the petitioner. Therefore, subjecting the petitioner to trial would be a futile exercise. Keeping in view the aforementioned fact and submission at bar, and in view of the judgment passed in Gyan Singh and Joshi, I am up for the considered review that subjecting the petitioner to trial in this case would be a futile exercise because the informant has already expired, and the LRs of informants are also not willing to proceed in the present case. Accordingly, the FIR number so and was. Yes.
88 day after tomorrow, so both the parties will remain together. Wife.
38. Yes. Next. 55.
55 may I please?
Yes.
The adjournment. The petitioner is challenging the order defects.
You tell me when you got the bail.
Page 24 minutes. Bail data
Data कौन तू 24 को?
37/12 bail.
37/12 bail. NBW 11/8
10/7/23.
10
NBW is 10/7/2023.
2023 500.
56 obligation.
Yes.
26/9/2023 is the order impugned. NBW was issued. He was in 41. He was under 41.
While investigation was going on, the petitioner was issued 41 notice, 41A notice.
On 5/12 wise.
The charge sheet was filed on 11/12/2022, showing the petitioner as absconded.
No, not arrested.
Not arrested. Not arrested. On 26/9/2023, the court below has issued NBW against the petitioner. Properly so 500. Yes.
57.
May I please, Your Lordship? Another NBW order 45, 4/3/2016 issued by Special Judge Hon'Ble. Earlier, he was bail hide order number 4/8/2004. Law SGM Hon'Ble. Answer 1, page 8.
2004 रे bail NBW वाला 4/3/2016.
हाँ 16 हजार का चलो.
Yes, madam.
8.
May please, Your Lordship.
58
Issued dated 10th of January 2024 and due to miscoordination between the council and the
bail date টা কোন তো?
বেল কেবে হইতিলা?
25th of 7, 2023 বলো।
হ্যাঁ
25th of 7, 2023
সরি
25/7/2023
25/7/23
25/7/2023
और NBW ला 10/1/2020
10/1/2024 ठीक है 500 yes
59.
59 वाला bail on 27/6/18 and NBW 12/1/23.
500 yes
60.
May Belgium matter, my lord, order number 22, 25 NBW issued. My lord, annexure 1, page 10, annexure 1, page 8 and 9, or bail, 2/2/2022, order number 9.
15/2/2022 ला bail, warrant ला 25/11/2022
500
Yes.
61.
Bail है 11/3/2008 11/3/2008 और NBW है 22/2/2016
2016
10 1000
62.
Belgium matter, my lord.
carefully
NBW is 26/12/20.
26/12/2013 NBW bail कौन तो?
The exact date of the bail is not
Bail date ही
they were in bail कर दियो तो करी की 1000
obliged. Highly obliged.
63.
yes
Bail ହେଲା 26/2/2024, NBW ହେଲା 10/4/2024.
Yes.
No, my lord, that is blood because of the exception of this honorable court has been violated.
10/4/2024
case है
1 minute he will appear and won't tell all the things
But not that. Not the chilling incident, the incident was the cause of the matter. That's why they this.
all right
Mr. Das name
give 500 and 1 perfect yes.
Obliged, man.
64.
Mayor, please, my lords. On behalf of Mr. Pal, my lord, NBW order has been challenged in this case. The NBW is
you will research here
27/2023
I was on bail, my lord.
27
हाँ NBW bail के bail जानी चाहिए
ये भी research करिए
Page 24 रे हजूर the exact date is not there. Order dated 5/8/19 रे ଅଛି. The committing magistrate reports that the accused person
500
bail.
कितने जन अछो तुम भाई हैं how many of you
अरे ये बहुत लोग अछंती एक 51
people
51
and you have no idea when they got the bail what is the offense nothing is there in one go 51 people cancellation of bail
Your lordship, may kindly see page number 24, my lords.
समस्त के अगेंस्ट गुटे ऑर्डर
yes yes my lord ये also में kind see page 24
24 my lord.
अपन किसी देखो ना इतने लोगों फाइल करते हैं जानना the committing magistrate reports that the accused person are on bail and have means to engage their own lawyer in the court of sessions order dated 5/8/2019 that's so
So all
they
these
were on
persons will
bail
NBW issued on 27
all accused persons
my lord, my lord.
non appear no steps
Within
taken
non-appearance-
how much you will pay
for head कितने देबे
51 people you think over that 10,000 rupees
My lords, senior matter, my lords. Maybe may take
10,000 रे divide करो 51 रे केते पड़ला जन को
200 टका लेखा पड़ दे
200 तो बोल तुमसे 5 टका बोल 200 तो बोल
से बहुत ही बहुत गया
हाँ।
51 में 200 लगा
कि 500 each कर देवी
No, no, sir,
जाओ पूछे जाओ 200,000 टका दियो बार को
obliged.
बार को दो तो काग दो yes
Highly obliged.
yes
65.
May I please, Your Lordship? Your Lordship, the impugned order that has been challenged is page 17, Your Lordship.
what is this order
Herein, Your Lordship, in a miscellaneous case for execution of the maintenance, area maintenance, Your Lordship, the Honorable Magistrate has issued a NBW against me without taking into note the fact that after the judgment, I have paid a part of the area
go and tell
maintenance,
you
Your
appear
Lordship.
and go and tell
Your Lordship, however, because of the issuance of
36,000
no, that is Your
you
Lordship,
are not paid 2,36,000 NBW issued along with the DW.
Your Lordship, how-
application was
Right
filed.
up. Petitioner is agreed by order dated 28/3/2024 passed by JMFC bracket T Barampur Ganjam in MC case number 271 of 2023. Subject to petitioner continuously paying the maintenance amount.
That
The NBW issued against the petitioner by the impugn order dated 28/3/2024 is set aside. The petitioner is directed to appear before the court below on or before 30th of May
Today.
also, and move appropriate application in accordance with the law. If such application is moved, the same shall be considered on its own merit. Yes.
Much obliged, Your Lordship.
66.
But subject to paying continuous maintenance.
Your Lordship, I'm contesting all the cases, Your Lordship.
Whatever,
However, a
whatever
part of-
maintenance are there.
Yes, Your Lordship.
This is regarding area.
Yes, Your
Keep
Lordship.
on paying maintenance and
Yes,
go
Your
and tell
Lordship.
whatever. Yes. Yes. Next 66.
May I please, your lordship? The petitioner praying for deletion of condition, my lord, fixed by the ADJ.
So which
Total
condition?
amount.
Show me condition.
My lord, kindly see page 19, my lord.
Show me the conditions, sir.
Page 19,
Yes.
part 3. She shall appear before the IO once a week, preferable in between 10 a.m. to p.m.
Co condition ta.
My lord,
3, condition 3.
yes, my lord.
What is the offense?
My lord, offense is 307, but the petitioner is a lady and the injury is simple, my lord. As per the my lord's kindly order, my lord, order sheet.
Petitioner is agreed by the present petition is moved by the petitioner under section 439 bracket 2 of CRPC seeking modification of the condition imposed by the court below while enlarging the petitioner on bail by order dated
Order dated, my lord.
by order dated 23/2/2024. The condition that she should appear before the IO once a week.
Once a
between 10 a.m. to 2 p.m. on every Sunday is modified to the extent that the accused shall appear before the IO of the case and as and when she
For the purpose of
she required, she is directed to be appeared for the purpose of effective investigation of the case. Okay, obliged. Yes.
68.
Allowed. Yes.
68.
Adjourned.
69.
On behalf of Mr. Bayardara, I kindly prefer an adjournment, lordship, because of.
Why are you seeking urgent? You can argue. What is the problem? What is this matter about?
Copy देना है.
Copy. Give a copy. Give a copy. Copy. Yes.
70.
70 also copy देना.
So adjourn.
71.
Jude Asunanti over to Koro. Yes.
71.
अच्छा, these are 22 matters, ना? July करो.
सब बड़ा defect है, defect बहुत defect है. Defect
What are the defects? नहीं, let us see.
4, 6, 18, 19.
Basic defect actually, we will dismiss it and ask him to file a fresh one. See, what are the defects? They filed, they don't come 22, they have filed it.
better, sir. 70.
They may not be interested also.
Otherwise, your lordship, parallel given their time. If that not removed in that period, then without reference to
Yes.
disposal.
The registry has pointed out certain defects. 71, na?
70 around 70.
Starting from 70.
70. Is 70, na? First 70. 70 के फाइल इतना
72 फाइल
1 minute 70 के फाइल इतना petition के फाइल हाँ the petition the present petition was filed on 5/8/2022. The registry had pointed out to certain defects. The defects has not yet been cured. By way of last opportunity, petitioner is granted 1 week time to cure the defect. In the event the defects are not cured, the petition stands dismissed without reference, without referring to the court. Okay, the same order कर दो 20 70
68 टा permitted to withdraw paper.
1 minute पढ़ गला और भैया
60 का अर्जन है
Permitted to withdraw.
1 minute sir 1 minute wait 68 urgent कर देते ना मैं
Permitted to withdraw.
withdraw करती हूँ करो withdraw 68 withdraw 68 withdraw ठीक है
70 का 71
70 come to 71
71 same order
71 रे भी तुम्हें ये कर दो खाली petition रो number date रख दो रखो the present petition was filed on 13/9/2022 the registry has pointed out certain defects the same has not yet been cured the petitioner is granted 1 week time to cure the defects in the event the defects are not cured the same shall be dismissed without reference to the court ठीक है
72 my lord, case become infructuous my lord. Trial already fornicated convicted.
Submits that the petition is infructuous, the dismiss is infructuous. Yes.
74
73 times.
withdraw it.
Withdraw. Yes.
74
Marital defect अच्छी की point out. 74. हाँ टाइम भी लिखो 74 रे लिखो. The petition was filed on this present petition was filed on 11/10/2022. Registry has pointed out certain defects. The same has not yet been cured. 1 week time is granted to the petitioner to cure the defect. In the event the same is not cured within 1 week, the petition stands dismissed without reference to court. Okay.
75
non-APS for the petitioner. सब लिखो. 71 तक देखिए थी non-APS for petitioner.
75
No.
कोई याद नहीं आते
70
75 टा it was lordship adjournment with the consent of the petitioner. Petitioner was there prior to it.
अच्छा adjourned at the request of the petitioner adjourned.
76
Yes. Are you share?
one defect copy sir.
Non-APS for the petitioner adjourned to second vacation reporter. No master dismiss for the petition the petition was filed. The present petition was filed on 21/10/2022. Registry has pointed out certain defects which has not yet been cured. Non-APS for the petitioner today. In the interest of justice, adjourned to second week. Next time, we will dismiss.
77
File it.
one defect.
One defect. The same. Sir, ऊपर order करो ना. Same order करो. The petition was filed on 26/10/2022. ठीक है? बाकी same. Yes.
78
Yes.
It may please your lordship the petitioners this is a case under section 498A 506
yes
323 IPC.
Yes.
The petitioners are all in bail. The petition number 1 Anjan Sharma is the husband. The petition number 2 Rubianet.
What do you want? What is your prayer?
My prayer is that to actually to quash the proceeding against the in-laws.
Why?
Because they are distant relatives, all are married daughters. Maybe and the rest are also their husbands. The mother is more than 80
How
years.
many husbands?
I mean Ruby, Pinky.
You say husbands. How many husbands?
Husband, respective husbands.
Respective.
Usha Kiran Sharma, she is now more than 70 years.
Matrimonial dispute simply issue notice. Issue notice to the opposite party number 2. आगे चलो. Next.
79
Issue.
Yes.
My lord, interim.
No interim. I'm not inclined, but matrimonial dispute will issue notice. You will see. Yes. Next.
79
But till then protection
79.
Yes. Yes, madam.
by registered post.
Yes.
Busting of the affair lost by the informant.
Obliged.
There is a dispute, my lord. There is a land dispute.
You are accused.
My lord.
You
My lord,
except FIR, you have filed
Except-
nothing.
My lord, only affair
Everything has
after
to be presumed and quashed. Investigation
lordship.
is going on.
investigation. It's a matter of 2022. My lord,
Maybe
as the
whatever You have filed only FIR.
My lord, I got the certified copy. As on that 23/8/2022, no final form has been filed.
I don't know. You have not filed anything. What can I do? Except FIR, nothing. You want everything should be presumed and quas.
22 ମସିହା that FIR also
FIR ଟା ହେଇଥିଲା
disappears.
22 ମସିହା। 22 ମସିହା ପରେ I got the certified copy. As on that, my lord, 20 in the meantime, charge sheet might have been.
I don't know. Charge sheet is filed.
My lord, nothing else, only that FIR
That's
copy
right.
and that is not legible also.
पास कर दे केमती करिवे किछि तो थिवा पास करिया पे किछि तो मटेरियल
My lord, your lordship is right, my lord. At the time of filing of the case,
petitioner seeks to withdraw this petition to file a better petition after the charge sheet is filed. With this liberty, the petition is disposed of. Yes.
80.
It's item 80 permitted to withdraw.
Withdraw.
Much appreciated.
Yes.
81.
81 रे कोन हिची भाई डिफेक्ट अछि
आज्ञा
क्या सेही जनरल हां सेही है से लिखो
Yes, same.
The present petition is filed on 15/11/2022 केते डिफेक्ट अछि
18, 19, two defect.
There are some defects are pointed out in the registry which has not yet been cured. 2 weeks time is granted as a bidder. 2 weeks time is granted to the petitioner to cure the defects. In the event it's not cured within that time, dismiss without reference to court. Yes.
82.
Permitted to withdraw. Withdraw memo is there.
84.
83 withdraw.
please lordship.
Yes.
My lord, item 84 kindly adjourn for 1 week. Defect, remove the defect.
81 टा 2 सप्ताह दिया
What is this matter?
remove करिवे
The quarrel between the landlord and tenants.
No, you are challenging what? Entire proceeding. What is the stage?
My lord, stage is the first stage.
The FIR was registered way back in 2022. What had happened? Investigation is over or not?
Both parties are mutually settled this case.
But you mutual settlement, you have to bring them.
I have not received any documents relating from my clients. So that's why I'm giving 1 week time. I will collect the documents and submit before this court.
Land Counsel for the petitioner seeks 1 week time to cure the defect. Release the matter before this vacation.
85.
It is made clear that no further adjournment will be given and the same will be decided in the next date appeal.
My lord, item number 81. I was absent, my lord. Non appears.
81, what did I do?
defect remove and after 2 weeks.
You cure the defect, otherwise it will be dismissed. Okay.
It has been indicated as non appears.
81 appearance. Yes.
85.
85 lordship Belgium matter. He was granted bail, anticipatory bail by order dated 18 January 2020.
18 January 2020.
Lordship.
18 January 22 NBW
And 18 January 2020.
16/8/2022.
2020.
NBW
16/8/22.
That's what I'm saying. 16/8/2022 NBW. ठीक है. Bail कोइला, bail date कोइला. हाँ?
18 January 2020.
18 January ठीक.
Good day.
500. Yes. Next.
86.
All Yes.
86.
Defect अछि.
Copies. Just copies. Copies.
None appears for the petitioner. The present petition was filed on 5/1/2022. Copy of the petition has not been supplied to the opposite side. Release the matter
1 week.
1 week after. In the event nobody appears, the same shall be considered. Same shall be considered on the next date appeal. Yes.
89.
May it please the Lordship. Lordship, this petition has approached this Honorable Court for quashing of the cognizance order dated 8/5/2018 which is in Annexure 2, page 20. The trial court took cognizance under section 409 of the IPC. The crux of the matter is that the petitioner, being the director of the Ganpati Paraboling Private Limited, has to deliver some rice, 44,911 quintal rice.
Opposite party.
Yes, my lord, notice was issued.
Just see service company.
It's completely a financial transaction and no case has been made out under section 409 IPC.
I have recorded.
Yes, your lordship, your lordship.
Service.
Madam, item number
89.
89. That's it.
89, my lord. Sufficient. Sufficient service.
Sufficient. Despite the notice, who the notice is na?
89 frequent labor suit.
Notice was issued to the opposite party number 2 on 12/3/2024. Despite the effective service for notice on party number 2, none appears today. In the interest of justice, matter is adjourned to next week kar do, before vacation kar do, and the interim order to continue. One opportunity has to be given. Okay?
Highly obliged.
Otherwise, you disclose it.
There is no case at all, my
I
lords.
know. I have recorded everything. It is a matter of recovery.
Yes, your lordship. Deeply obliged. Even there is no recovery at all. Even after that, they again demanded 5 lakh rupees.
You have already paid.
Yes, your lord. I have paid the entire amount. Apart from that, another 5 lakh I have paid. I have submitted all the
That's what I have
documents.
recorded here.
Yes,
Let
your
us
lordship.
see, verify the fact.
Your lordship.
See.
Deeply obliged.
90.
May I please lordship?
Interim order to continue.
May I please lordship? On the last petition, lordship directed to file the requisite. And we have filed the requisite. Right for
the interim order was passed once. When? See, I passed the interim order on 8/2/2024.
my lord.
And thereafter the matter was taken up on 14/3/24. And today this is the 3rd day. You have not filed requisite. Shall I vacate the interim order or you
Today
pay?
we file. Today we file it.
Today, because morning when you attempted to mention and get it adjourned, when I asked, then you become wiser and went and filed. But you have to pay some cost to the bar. No, you have to pay. Otherwise, I'll vacate the interim order. You decide. You give some cost to the bar, because interim order you have taken, 2 dates have gone by, and you have not filed.
Excuse me for this time.
It's all right, 500. Subject to petition, land council and the petitioner submit that he has filed the requisite today for service of notice on opposite party number 2. The subject to petitioner depositing rupees 500 to work except the requisite. Once you take interim order, you should be diligent,
91.
This trick will not work. Once you take in, otherwise I'll vacate it. Give 500 rupees. Yes.
91. May I please?
Yes.
My lord, on the last occasion had directed to High Court Mediation Center for settlement. The notice was issued to the opposite parties, but they have not appeared, and the matter was fixed on 17th of this month. My lord, before that, if lordship will.
The matter is fixed on 17th of
May.
17th of May, before the mediation cell. Adjourn the present matter beyond the light, awaiting the mediation report.
And to draw lordship's kind attention for her 1 minute, the contradiction as regards to affair and the agreement to sell is all regarding.
What do you want? Your mediation is going on. I want to decide into our merit. You complete the mediation. If mediation fail, you will be yes. Whatever merit you have, you are okay.
Yep.
Awaiting mediation report. Okay. Hey, there is a mediation report.
That report shows the same thing, my lord.
Achha.
Lordship, may I?
No, it's all right. Again, date is fixed. Okay.
92.
May I please, my lord? My lord, in this case, my lord, I have prayed to pass the criminal proceeding against the present petitioner. My lord, background of this case is like this, my lord. The informant has alleged that he has purchased a land measuring about 10 decimals. There are 14. And adjacent to the said plot, there are some vacant government lands. It is stated that during taking advantage of the absence of the present informant, the petitioner's family members, they have encroached upon the land in question. That is the allegation. My lord may have a glance to the affair story. And as far as the present petitioner, who is a newly married girl, married in the year May 2023, my lord, and her husband is a permanent resident of Canada. My lord, soon after the marriage, he has gone to Canada and now she is staying here because no visa or passport. In this case,
Who?
my petitioner, my lord.
The petitioner.
And she has no role at all in this case. The entire family members have been implicated. My lord, the entire family members, they have been implicated. 9 of the family members, they have been implicated, including the grandfather and the father, and also the uncle and their aunt.
Mr. Maharaj,
My lord.
can you spare this girl?
Blood, this attitude and your lordship may kindly say the charge sheet.
She is newly
Every
married,
role
husband has
is
gone.
that is not because the
No, just examine whether what is the role against this.
Yes, my lord, she has not. My
It is
lord.
there in the charge sheet specifically.
Let us see.
And one application is pending before your lordship. Another application is pending. Serial number 7792 2024.
No, that has not been pressed because defect could not be removed in that case. So this is the first application in which I have entered into appearance.
You have not given reference. Why are you?
My lord, this application was filed first.
No, one petition is filed and you have not.
Because by that
application.
You have to declare.
I will file a declaration.
Not I will. Why you haven't? That is
Yes,
the question.
yes. By tomorrow I will file a declaration.
Once you pointed out, then
Yes.
No. This is
By tomorrow I will file a declaration.
tomorrow you file. Then tomorrow we may not have time.
Yes.
That's the problem.
No. Tomorrow I will file.
Listing is so difficult.
My lord.
Once it is listed, you have to avail that opportunity. Otherwise, it is gone.
Yes, that I know.
Go to July only.
Yes.
There is no question of accommodation. No question of accommodation. You have invited that what to do. What is the allegation?
Allegation as far as petitioner is concerned, there is no allegation, my lord.
All the family members, including the petitioner, taking advantage of its absence, some villagers. But the land is a government land. In fact, it's a government land. This has been acquired by the complainant. He was peacefully enjoying that property, and there is a house on the property.
In the government land.
Government. That is no disputed that.
Informant was in that government land?
Yes. That since in his absence, these accused persons forcibly entered into the house and assaulted the informant and other family members.
They want that the government land they should encroach instead of informant.
Exactly.
Yes.
So these are the dispute. So you don't have any right. Why you assaulted? You should have complained before the any authority. But you don't have a right to assault a person.
Assault.
So yes, that is there. That is the allegation. On this, time and again, on receipt of information about the matter from some neighbors, he has filed a case under section 144 of CRPC with the help of his brother. Brother means a complainant or brother. After that, he came to know that the said people are outsiders who forcibly occupying the government areas and forcibly staying there. Due to lockdown of COVID-19, when the complainant returned to his house to take care of his land area, said alleged accused Santosh Samal, Soni Samal, wrongful destiny. On this, he informed the matter at Chaudhar PS on 27/8/2021, and with the assurance of the police, he started his work again in his land. Again on 28/8/2021, said alleged accused persons assaulted him and his laborers, those who were working there, and abused them in obscene languages and
where are the statement?
Statement would happen.
ଦେଲେ ତ ଜାଣିବେ ସ୍ପେସିଫିକ ଆଲିଗେସନ କଣ ହେଇଛି ଆପଣ ଡିକ୍ଲାରେସନ ଦେବେନି 164 161 statement file କରିବେନି how will I
let it come next week. I will file all those statements of the witnesses.
File and Counsel for the petitioner seeks time to file additional document to substantiate the case and file an affidavit regarding any other case pending, any other case filed by the petitioner or the co-accused pending before this court or not.
Date may be fixed next week. Any date may be fixed.
He'll give a date.
93.
May I please, your lords?
My lord, the petitioner filed this IA for modification of order at 31/2024, in which my lord has ordered that to furnish my lord at para 3, my lord directed to furnish the cash security of rupees 1 lakh and property security of rupees 8 lakhs. My lord, since the property security has been mentioned in the order sheet, my lord, the Law and Trial Court has opined that the original ROR will be kept in case record till finalization of the trial, my lord. Therefore, the petitioner, who is a landless person, my lord, belongs to ST community and by caste
You
suffer.
don't want to give it the ROR so that you will sell it.
नहीं property
Your security रखी शायद
नहीं नहीं क्या सिक्योरिटी मो 1 लाख जोड़ा है जिसे अरेंज कर पाने 50 लाख पेमेंट क्या जो प्रॉपर्टी सिक्योरिटी डा
So what is the mode of property security? How will you give the mode?
मेरा आज like as property security means the bail bond like मेरा
ସେ କହୁଛନ୍ତି ସିକ୍ୟୁରିଟି ଲେଖା ହେଇଛି ସେଇଟା ସିକ୍ୟୁରିଟି ହେଲେ ସେ ତାଙ୍କର ସଫାଇ
सती like the original
The Land Council, the petitioner has moved this application seeking modification of the order dated 30/8/2024, whereby this court has directed to furnish the petitioner cash security of 1 lakh and property security of 8 lakhs, along with the indemnity bond for the entire amount. He seeks the modification to the extent that instead of property security, he would furnish property security.
Yes.
The application is modified to.
ତାଙ୍କର କ୍ୟାସ୍ଟା ଅଛି କ୍ୟାସ୍ଟା 1 lakh ରୁ 50,000
my lord,
it is modified to that extent.
my lord to 50,000
धीरे धीरे
नहीं 3 months से रहिलाणी देई पारनी रेगुलरली इंस्टॉलमेंट दउजी फाइनेंस कंपनी
I have modified so many times. Now genuine problem you have that I have taken care of.
belong to ST लोगों सब बार बाइक
Next
paying the regularly installment.
ସରେଣ୍ଡର ଟାଇମଟା ଏକ୍ସଟେନସନ ହବ
Surrender time
94.
In view of this confusion, he could not surrender himself.
next time
94 man.
90.
next item
Yes.
94 my lord. I pray 1 week time, Lord. What is happening, my lord? As per your lordship's
ସରେଣ୍ଡର
direction.
ଟାଇମଟା ଏକ୍ସଟେନସନ ହବ ତ
Now, your lordship direction, I appeared. I came from Mumbai and appeared in the lower court. But I was asked to serve the copy upon the other side. The other side didn't turn up. For which that day the said petition could not be moved. So in the meantime, yesterday only I heard that the complainant is expired in the meantime. So I have to take specific instructions. So I pray 1 week time, your lordship.
ଆର୍ଜନ ହବ
Yes.
Lord, the NBW the entry order may continue, Lord.
Entry mode कौन होता है? Satisfied कर दीजिए ना.
ଏକ୍ସଟେନସନ ଟାଇମ ସରେଣ୍ଡର ପାଇଁ ଆସିଥିଲେ କଣ
ଆସିଥିଲେ ଫେରିକିନା ଗଲେ.
Meantime, the complainant has died.
Lord, yesterday I got information that the complainant is expired.
Like the, what was the order item?
Item
94.
94 na. 1 minute. 94. Time कितनी दिया इतना?
The petitioner is directed to surrender to jurisdiction of learned court below and avail the remedy under law.
No, you are on or before 5/4/2024.
My lord, I appear on 3rd.
I extend to June, first week of June. By that time, everything will be sorted. Okay. Land Council for the petitioner seeks modification of the order dated 7/3/2024 on the ground that the complainant in the present case has expired. So therefore, although he surrendered, he could not supply the copy of the
Counsel of the
copy of what?
The bill application.
Copy of the bail application to the complainant. Meanwhile, the complainant is reported to be expired. Therefore, he seeks further extension of time to surrender before the court below. Taking into consideration the aforementioned submission at the bar, the time for surrendering of the petitioner before the court below is extended up till 15th June.
My lord.
15th June 2024.
50th June, my lord.
June na?
June.
20th June for this.
My lord.
20th
June, my lord.
20th June and await remedy under law.
The NBW which was has been kept in abeyance till then.
Yes, NBW that
Say on, sir.
extension and rest of the part of the order remains here.
95.
May I please, Your Lordship? 95, Your Lordship, on 8/2, Your Lordship, please to issue notice and state the further proceeding. And in compliance the direction, I have filed the requisites, notice issued, but in which address he has filed the application, refused for, he is not there, Your Lordship. Door closed report as well, that I record. Then, Your Lordship, on 12th March, matter was listed. Your Lordship directed to take notice in fresh address, Your Lordship. But I could not get fresh address, Your Lordship. Today I get the fresh address. I will
consider the petition submits that he could get the fresh address of opposite party number 2 today, and the same would be placed on same would be filed in the court during the course of the day, and he would take necessary steps to serve the opposite party number 2 in the fresh address within 2 weeks. Hence, adjourned to entry order.
On it place copy, Your Lordship, and direct
Entry order to continue.
On it place copy we utilize. Then I have to file one corrected cost title.
Unutilized copy for the petition may be used for the purpose of serving the notice.
And only corrected cost title I have to file, Your Lordship. Your Lordship, direct. Otherwise they will not accept. Inserting the present address.
Corrected copy of
Correct address of the
corrected cost title.
memo parties.
Yes,
corrected memo parties. Yes.
Obliged.
96. 96. May I please, Lordship.
My lord, in the order dated 23/2024, your lordship directed to issue notice to the opposite party known to
the service allowed.
As per noting, my lord.
Service awaiting adjourned. Entry mode to continue.
Obliged, my lord.
Yes.
97.
Yes.
360 rupees ଦେଇନାହାନ୍ତି 3 ଟଙ୍କା 60 ପଇସା ଗୋଟେ ଦେଇନାହାନ୍ତି
97.
Yes, 97. A cost title or semi kindly say. Deficit authentication fee of rupees 3.60 not paid. Hence defect number 3 not yet received. But let them to remove the defect.
Right. The present petition was filed on 7/12/2023. The registry has pointed out certain defects. The same has not yet been cured by the petitioner. 1 week time is granted to cure the defects pointed out by the registry. If the defects are not cured within 1 week, the petition shall stand dismissed without reference to the court. Reportedly, they non-appeal for the petitioner.
Yes.
98.
This matter, my lord, earlier notice was issued. It has been returned because the person has left for Hyderabad. I am supposed to take a fresh steps with the correct address.
The petition seeks further time to take fresh steps to serve for the opposite party.
Within 2 weeks, I will take steps.
Opposite party, he may take appropriate steps within 2 weeks to serve the opposite party in the fresh address.
Yes.
In the fresh address to be furnished by the petitioner. Adjourned to also entry mode to continue.
Entry mode may continue.
Entry mode to continue.
Obliged.
Yes.
99.
I recognize by entry model.
No entry model. Petitioner to file charge sheet copy of the charge sheet. Charge sheet copy not filed, it adjourned. Let it be adjourned.
Why adjourned? This is correct. 8, 1, 2, 3, 4, 5.
Yes.
5 dates. Yes.
Charge sheet is to be procured. That's why
5 dates you have taken.
Short adjournment.
What are you seeking here?
Discharge petition rejected. 227 of the CRPC.
The petitioner has taken 1, 2, 3, 4, 5 dates. Petitioner has taken 5 days to file the copy of charge sheet. when the matter is taken up today, again the counsel for the petitioner seeks time to file these additional documents. In the interest of justice, one more final opportunity is granted to the petitioner. It is made clear that in event the necessary documents are not filed within 1 week, the petition will be decided on merit on the available documents, and no further adjournments are granted.
Okay, Judge.
Yes.
100.
Please, my lord. My lords, herein the petitioners have challenged the order of cognizance taken against them, and on 22nd to 2024, my lords was pleased to issue notice to the opposite party number 2, my lords. And the noting has come that the addressee is not found, my lords.
Addressee is not found.
Not out address ଅଛି ସେଥିରେ ଦିଅନ୍ତୁ out address ଅଛି.
There are in the petition, the
yes.
petitioner has given alternate address.
The notice
out address ଅଛି page 20 ରେ.
20.
Yes. Srimati Nandini Sahu, aged about 24, daughter of late Sushant Sahu, Hindu, household duties, village, Kama Street, Post PS, Digopandi, District Ganjam.
Yes.
He address
in that address.
He address
notice may be issued through the investigating officer.
No, you take it.
अरे आपनकर address अछि दियंतु. Press requisition.
Petitioner is directed to serve the opposite parties in the alternate address given by the by who is petitioner?
Petitioner is the husband perhaps.
By
Annexed for the address which is given in the same matter also she did not appear.
Given in the page 20, na?
Page 20.
Given in the complaint petition. Given in the
yes.
Civil
proceeding number 57.
Civil proceeding number
57 of 2021.
Same
bracket
she did not appear.
Annexure 4, eh?
She did not appear in the same matter as well.
But you filed, there are 2 addresses. It has to be complete.
ये address का complete कर दियंतु भलो होगा.
कौन लिख लो? Directly serve the opposite party in the address alternate address given in the civil proceeding number 57 of 2021 annexure 4 to this petition. This is the matter.
Okay.
100C.
Modification of the order dated 28 February 2024, my lord, in place of PS case number 78, it has been inadvertently given in my cause title as 80. My lord, may I have a glance to the FIR? I have also enclosed.
No, what city case number?
City case number that should have been 59, my lord, and instead of it has been ordered as 66.
You might have written some.
My lord, in the cause title it has been wrong because fact remains what happened. The case was
I don't
committed.
want that. Right on. Correction करो it. Order dated 28/2/2024. अरे city case कितने हुआ था?
59 of 2023.
City case number 59 of 2023.
And PS case number 70.
PS case is same?
PS case number is 78.
What are the offences there and what are the offences?
अच्छा से जो PS केस टा अच्छी तरह FIR पर
Yes, FIR अच्छी. FIR.
So casually you find that's the whole definition.
No.
PS case number 78 of 2020.
My lord. 78.
Right on. 78. PS case number 78 of 2023 or it of 59 of 20.
Yes.
Yes.
78 ର GR होची 476.
तापर सिटी है आफ्टर कमिटमेंट.
चलो ठीक है.
अब नेक्स्ट
104.
Extension of surrender. Extension surrender date.
Well, on behalf of Amilya Ratra Panda, his clerk just now requested me.
What do you want?
He's held up in some other court. So
surrender time टा
yes, ma'am.
Surrender time. Surrender कभी दे ही टाइम ऑन और बिफोर 22/5.
Yes.
22/5 बहुत दिन अच्छी. तो बुड़ गई.
गोटे 22 29/2 थिला ऑर्डर डेटेड 29/2/2024.
डिड नॉट अपीयर 22/5/2018. सॉरी आई एम सो सॉरी. 22 मार्च थिला ऑन और बिफोर 22 मार्च. हां एक्सटेंड कर दो 30 में जाएंगे
6th में क्या कर देगा
30 में ठीक है
Yes.
all other remaining things will remain ठीक है
105.
My lords, on behalf of Mr. Panda, permitted to be withdrawn as infractors.
5 105
105.
Land counsel petitioner submits that the petition has become infractious, appeal become infractious, the appeal is dismissed as infractious.
Obligation, my lords.
106.
May I please, Your Lordship? My lord, I am permitted through virtual mode, my lords.
Yes.
My lords, a murder case with which the investigating agency is playing hide and seek before this honorable court, and after an order,
You show me the order which you
order
alleged to-
dated, my lord may go through order dated 1/2/24. It contains everything in detail. It's a very lengthy order.
which
1/2
order you according to you is not compliant.
Millers, kindly go through order dated 1/2/24. It contains the whole thing.
1/2/24.
This year, February 1st, 1/2/24.
Yes.
My lord may go through that. It contains everything.
Yes. Yes.
There the order has been quoted. My lord may kindly go through that.
Yes. Yes. Which para?
The whole order, Millers, because it contains the whole saga. The page 2, it has been quoted, the order of this honorable court. May I place it, Millers?
Yes. Yes.
In the aforesaid circumstances, while declining the pair for transfer of the investigation of Crime Branch PS case number 10 of 11 to CBI, this court directs the Director General of Police, Crime Branch Orissa Cuttack, opposite party number 2, to change the investigating officer concerned and engage a competent and efficient officer not below the rank of Deputy Superintendent of Police, who shall conduct investigation without any break and complete the same. This order was passed on 20th May 2016, my lords. Thereafter, they were asked to show cause.
Let
Yes.
me
Sorry,
read it. Otherwise, how will I know?
No, I wanted to know. I wanted
You
that.
know everything. I don't know. I have to read it. Huh? What is the substantive order part?
My lord, substantive order is like this, my lord.
My lords,
The case was-
second page, which was
Let
been
me
quoted.
complete. In the aforesaid circumstances, while declining the prayer of transfer of investigation to the crime branch, case number so and so to CBI, this court directs that the Director General of Police, Crime Branch Orissa Cuttack, opposite party number 2, to change the investigating officer concerned and engage a competent and efficient officer not below the rank of Deputy Superintendent of Police and who shall conduct the investigation without any break and complete the same expeditiously. And what is the contempt? You tell me now.
My lord, we have submitted charge sheet, my lord. And last occasion, my lord, this honorable court direct the SP, my lord, the charge sheet submitted by the DSP crime branch, my lord.
Yes.
And this honorable court direct the SP, my lord, in paragraph 6, my lord, in view of the matter, it is directed that
Paragraph 6 of-
affidavit.
6 of what? Which order you are talking?
My lord, 1/2/2024, my lord.
Yes. Yes.
My lord, paragraph 6, my lord.
Hmm.
In view of the matter, it is directed that the affidavit placed by the DSP Crime and CB Cuttack before the court be placed before the SP CIDCB, who will examine the same besides the case diary in detail and submit a report in the investigation has been proceed in the right direction, and if any lacuna is found reaching its finality, and if so, why the report was not submitted soon after completion of the investigation as seen to have been completed in the year 2016 was lying over. Whether inspection have been made by the SP CIDCB in the meantime in the matter, and a remark in the matter in the investigation, if any, be placed in the report, my lord. That is the SP is there, my lord, appearing, my lord, through virtual, my lord.
Yes.
They have, my lord, submitted the report, my lord, and matter was listed on, my lord, on the last Friday, my lord.
Yes.
I asked them,
what
they
remains?
filed the affidavit, my lord. Charge sheet has already, final report has already been submitted, my lord. And he verified that the.
No, 1 minute.
My lord.
Mr. Sadangi, what remains?
Yes. No, my lords, it's not that simple what he is saying. My lords, how they are playing, your lordship may see. Now, they say.
No, see, I am not on that. What I am trying to tell you is the
Yes.
order you
No, my lords, the contempt has already been committed. It's not a compliance report.
What was the order? What was the order? Order is
Order is to
only
investigate.
say
Milords,
that it has
Milords,
to be
if your
investigated by a
lordship-
competent authority.
If your lordship
Like the
allows
expedition
me,
as possible.
if your lordship allows me 5 minutes time, Milords.
Yes, yes.
Milords, reason your lordship knows some high profile people, how they have investigated. If your lordship goes through the show cause, it's pathetic. Suspects are not arrested, they were interrogated and their alibi plea was accepted. And they played the game in the investigation for which a specialized agency we prayed for, but it was
Faulty
declined.
investigation can't be gone into in a
Thereafter,
contempt
Milords,
jurisdiction.
thereafter, Milords, last occasion before passing this order, Milords, before that, this order itself, that's the reason I'm saying that the whole, your lordship should go through the order in full. This honorable court called for the case records. Case records were produced. Case records indicate that within the last 7 years, there is no progress or no investigation has been done. Then simply, instead of filing a final report before the trial court, what they did, they filed it here before this honorable court. So this honorable court passed the order that for 7 years, if you are silent, if the investigation is completed, then you should have filed a final report then only. Now, what further investigation within 7 years? The case diary disclosed that there was no investigation. And again, the show cause which was filed in 2014, that has been copied. That is the order, Milords. I'm
1
reading
minute,
that.
what is, I didn't follow. What is your grievance? See, 1 minute, wait on. The substantive order was, you sought for CBI, you sought for transfer to CBI. It was declined and direction was made that a competent officer of the rank of DSP should conduct the investigation and expeditiously file the charge sheet.
Yes, Milords.
Now, wrong, right, whatever, how many years they have taken, I don't know.
Not wrong,
Now,
right, Milords.
now they have filed the charge sheet. What is the contempt remaining?
They have not filed the charge sheet. They have filed a final form. I am not on that. Milords, 7 years.
You file protest petition.
Exactly. That is a different aspect, Milords. That is a different aspect. I am placing the order itself. Your discourse order.
Does the order you are alleging contempt says that you have to file the what you call, where is that order?
Milords, the order I am referring to, it contains the whole thing. It indicates that for 7 years after this High Court's order, the CD indicates that no order has been passed. No investigation has been done. Merely for eyewashing, the order was not passed. A final report, Milords, I am placing further. I am placing the order itself. Same page. Next, what this court has observed.
Come to page 20 of the petition.
My petition, Milords.
Yes.
But they complete the order.
I read it. The contempt jurisdiction is very limited, sir.
My lord, exactly. Charge sheet, final report submitted, my lord. Thereafter,
can't
this
go
will
into all
directed the
this.
SP.
Maybe you are 100% correct. They have already messed up everything.
My lord,
but in contempt jurisdiction, how far I can stretch?
No, not stretching.
You obey the order of this court.
Come to the order. Order you are complaining of non-compliance. Come to the order. Page 20.
Milords, yes,
This is the order you want to be
Milords,
complied.
I have already.
And they have complied it.
I have already placed. Milords, they have complied then also. Then this court would have dropped the proceeding if it has been complied with.
I don't know what weight that might have that. I don't know. Today I have to see what was the order, whether the order is complied or not. If it is, if you are not satisfied with that compliance, then you can file protest petition. You have remedies are there.
No, that
But how the contempt is made out?
Milords, merely without investigation, after 7 years, when notice is issued and court takes it seriously, you file a petition and then you say it's done. Can it be sufficient compliance in the real spirit of the order has been complied with? That is my humble
Then what you are saying is,
para 5 of the order.
I need not go into the order of interim order passed in the contempt. Final order, which was supposed to be complied, you come to that.
No, I am on recording of facts, Milords. How can these facts be ignored on the face of it? That is the question that comes to my mind, Milords. All right, let me praise it, Milords, for your lordship perusal.
I think
ultimately order is your lordship, Milords. I cannot quarrel over that. That is your lordship's prerogative. I do understand.
No, it's not.
7
I
years
have to
after
also go by law only, not prerogative.
Milords, 7 years after it's being taken up, at least 7 minutes I should have the chance to say.
Yes.
My lords, I'm just reading that order, paragraph 5.
5, okay.
Perusal, lordship got it?
Yes.
1 to
Perusal of
24.
reveal.
Yes. Reveals that the investigation that had proceeded pursuant to the resumption of the charge of the investigation by the CID in the year 2010 continued till 2016, and thereafter nothing has been transpired in that investigation. However, court called for the case diary, found that and recorded this. In 16 it was over. Thereafter no proceeding. They have done nothing. The city never indicates that any step has been done. Now merely 2 papers are thrown in a court and say investigation is complete. And if that is the compliance of the order.
Have you, Mr. Raghunath,
I'll appeal it, my lord. So that
after this order?
My lord.
Where is that?
My lord, on 26th, my lord, on 26th, I have filed, my lord. That is with me, my lord, online. Online I have filed with this, my lord. And that happened, my lord, also the compliance report was given to this office, my lord. Thereafter, after last occasion, my lord, on Friday, that has been filed, my lord, and scan the same, my lord. My lord, can't see. My lord, but that has been scanned, my lord.
I don't have a copy, my lords.
So the Bhuvan sir also court gaithal court dihante.
I kali dikhaital delini.
Kali court kali chutithala. शुक्रवार में फाइल करछि
आपण कंप्लायंस एफिडेविट देखंतु तापर कंटेंट
हे छि भाई कंप्लाई करछंती
आया हेई परिबोनी दे कैन नॉट गो बैक एंड एक्सप्लेन
आपण मेल कर देन तो मेल मिस्टर रगड़ा लेट काउंसिल सबमिट्स दैट he has filed the compliance report compliance affidavit dated 26th April 2024. Mr. Sadangi submits that he has not received the copy of.
Tomorrow he can hand me over.
He may be supplied during the course of the day.
Asinath Bhuvan sir
phone call mail ID WhatsApp report आगे पठा दो. During the course of the day, leave the matter for further hearing. They do. Friday. Third,
personal appearance may be dispensed with.
Personal appearance of the officers. Officers who
SP and DSP.
Was there any order of personal appearance?
Earlier 29th that was the
personal appearance of the contaminants, alleged contaminants are dispensed with. For the time being. At this stage. Yes. Continue. Exist for the book. Yes.
107.
107, let's see, first item. This is a transport brief. I filed my Vapalatnama, but power has not come. That's why I couldn't mark the list. Let's see, take up any other day. Interim order to contact.
Interim order to contact.
Interim order is what interim order I am appearing for the informant, my lord. On my basis, this. And in that case, as per my instruction, the case is proceeding before the trial court. And commitment, perhaps today the case has been committed. As per my instruction, I have also. A short date may be fixed.
There is an interim order already. Interim order further proceeding state.
Yes, madam.
So how the matter is proceeding?
I don't know, as per my instruction.
You seek proper instruction.
A short date may be fixed.
108.
May I please, your lordship? There is a case, my lord, challenging the criminal proceeding.
107, interim order continued till next.
Yes, till next day.
Challenging the criminal proceeding in a complaint case under section 220, 191, 342, 500, 5006, 294, 323, 34 of Indian Penal Code by the learned SDJ Bhubaneswar, my lord. Petition number 1 is the daughter-in-law of the complainant. Petition number 2 is the father-in-law, and 3 is the mother-in-law, my lord.
Notice was issued or not?
Yes, my lord. Already appeared, my lord.
Who is appearing?
I am appearing.
My lord. In this case, my lord, lordship, I have last occasion, my lord, the petition number 1, he has also appeared in before this honorable court, my lord, filed affidavit and date chart, my lord. On 11/5/2012, my lord. Initially, my lord, the petition number 1, namely Lipi Puspa Rosaline, lodged FIR against her husband and other family members under section 498A, 294, 323, 506, 34 of IPC and section 4 of Dowry Prohibition Act before the Mohila Police Station, Bhubaneswar, my lord. Thereafter, my lord, after 7 months, my lord, a complaint case was filed by the father-in-law, my lord, in petition against the petition number 1, subsequently registered as 294, 323, 380, 506, 34 of IPC, filed Jaipur Town PS case number 25 of 2313, my lord. And in that case, my lord, that case has been quashed by this honorable court, my lord, by this honorable court in CLMC number 3147. Let's say, mechanic glance, I have also given that copy, my lord. And observing that this is the counter blast, this case has been posted, my lord. And thereafter, my lord, after 1 year, on 23/4/2014, my lord, complainant Basanti Satpathy, mother-in-law, my lord, filed a complaint case, filed 1CC case number 1416 of 14, my lord, for commission of offence 220, 191, 342, 500, 506, 294, 323, 34 by IPC against the daughter-in-law and others, my lord, including the police officer and his sister.
Is there any legal bar?
My lord?
Is there any legal bar? You can file if the offences are committed. It's filed, cross case.
No, again filed.
How do I know it is
Initially,
found
498A has been filed. Thereafter, in order to harass the petitioner, thereafter filed complaint case one by one. One case has been quashed by this honorable court, my lord. And thereafter, on 27/8/21, my lord, on 27/8/2001.
Which case is quashed?
Yes, my lord, quashed by this one. On 27/8/2000, the husband of the petition number 1 and other in-laws family members, my lord, including the mother-in-law Basan Satpathy, who is the complainant of this case, have already acquitted by the learned JMFC Bhubaneswar, my lord.
How many cases are there against each other?
My lords?
How many cases are there?
They have filed I have filed one case, my lord.
You filed one case against them.
498A.
They filed?
They filed 1CC case, 2 1CC case, my lord.
How many cases? How many cases?
Two cases, my lord. What a mother-in-law file kare, what a father-in-law file kare.
Against the daughter-in-law.
Against daughter-in-law and other family members, including the police officers. I instituted the 498A case, my lord. And in this case, my lord, 498A case, the lower court.
1 minute. Why are you not settling this family dispute? What is this going on?
My lord, 1 point, my lord.
1 minute. I'm not hearing it. I'm taking an overall view.
Other data. At her instance, your lordship, all of us were in jail. Since 300 hours late night after 8:30, the Human Rights Commission that came into play and penalized the police officer. 50,000 rupees. There is subject to a dispute in the read petition.
She has initiated 498A.
She initiated 498.
In 498A, you were arrested.
498A has been acquitted.
498 acquitted. That is correct. They could not prove it.
They did not could be no. They told not support. They told I filed affidavit, my lord.
1 minute, let me understand. You are bringing so many facts. How will I understand?
They hotly contested the matter until the time they found that they are not getting any support to support the case. That's why they are now saying that we did not contest, and there are assurance from my side that I am not.
Anyway, 498, you have been acquitted.
I have been acquitted.
The case initiated by her against you, you have now been acquitted. And the cases which you have initiated against her is going on. He wants those proceedings to be quashed in this.
Yes.
The divorce has been allowed. Ex parte order.
Not ex parte. See,
ex parte order. Ex parte order.
Here, in spite of repeated notice, your lordship.
Now the divorce has already been granted.
Yes.
Yeah,
you have been acquitted.
One case
they are now free. You are not free.
Only one case is there. Other case, other case, my lord.
What is the alimony?
One case has been quashed. No, only one yard. Ex parte order was passed, my lord. She did not appear.
Have you challenged it?
No, my lord.
Then
my lord, husband, my lord, I have filed affidavit. Husband told. Husband told we have decided to compromise the dispute, my lord.
Compromise, then bring them.
Compromise the dispute. But after they have been acquitted, they have not supported us.
Obviously. They are now free.
Now free,
Your lordship, this
ଆମେ କେମିତି ହେଇଗଲା ସବୁଥିରେ ଆଜ୍ଞା ଆକୁଟାଲ ହେଇଗଲା
Expertly, divorce
ଏଇଟା ହେଇଗଲା
you don't challenge it.
ଓପନ ନାଇଟେଡରେ କହିଲେ ଯେ I am not proceed I am not I do not want to proceed with this case United ବି ଝିଅ appear କରି କହିଛି ସେଟା ଫାଇଲ କରିଛୁ ଆମେ
Now, Mr. Chodgi, now leave there.
out of
You are now acquitted.
It's not a question.
You
like
got
that, my lord.
expertly
No,
divorce.
no, no. Your lordship, the humiliation, my son, younger son, who was getting admission and Massachusetts University, my lord, in America, he could not go because he was put behind bar. These
Let bygone be bygone. You will not get anything out of it by sending them to jail.
My lord,
You are not going to get anything out of
what
it.
I have lost, my lord, I am saying. My son, the elder son, her husband, he was employed in America then. Now, this, my so-called wife of with his wife and the sister-in-laws, what they did, they wrote to their employer, and in fact, that is also part of the FIR also, my lord, that he is a Marxist. Sorry, Koraput area, Naxal. Naxal. As a consequence, he lost his job. Now he is jobless ever since then.
Then it needs hearing. I think you should settle it.
ହେଇ ଗୋଟେ କେସ୍ ଆଉ କିଛି
Cognizance was taken against the police officer after sanction from the government. It is not just like that, my lord. Government
she has
applying its own.
she has performed his duty
Because the Human Rights Commission is taken cognizance.
Human rights is one part. Government gave sanction under 197. That is how the police officer is prosecuted. In this case, cognizance order. Cognizance.
In this ICC case.
no my lord
Three cases are there.
I am talking about this ICC case. What is this?
This
All
ICC
three
case,
came together.
there are 5 accused persons. Right? No?
yes my lord
This is one. Second relates to other 2, and third is of the police officer.
daughter-in-law
One order.
daughter-in-law father-in-law and mother-in-law
And police officer.
police officer
And sister-in-law also.
and sister-in-law and husband they are residing in outside
Sister, yes, as soon after they got it, my lord, they
After
lost
the
their
marriage,
job also because
they have.
they also manipulated many things. That also I will place before
While-
lord.
while crossing my lord
All arm twisting.
this
Everything on record.
this honorable court also observed in the previous case
Hearing me.
the case has been quashed
And
on
by quashing your-
3147
I'll hear it. There is nothing.
Without notice to the
You people have decided to fight it out in the court for years together.
My lord, help us.
Help us.
Otherwise, no.
personal appearance now how it aସନ୍ତୁ
Out of 3 cases, out of 3 cases.
No, what they are saying is if you give
Yes.
little,
The
you will
lady-
be,
Because
your grace will help
Yes,
them
yes,
to
yes.
get out of it.
It's not my grace.
My lord,
Right.
senior can
The lady
Ask
has
them.
become old. His father has become old. The loss to the family, my lord, you will realize.
They'll compensate you.
Just because I am from Koraput, my lord.
Are you
I have right.
ready to
lord.
compensate financially?
whatever the
Are you ready to compensate
Your
financially?
lordship, I hear it, my lord. Your lordship.
Honorable Justice SK have also observed, taking into account the nature of
There
acquisition.
was not notice. There was not notice.
My lord, whatever may be the out of 3 cases, 2 already gone. My lord, one quashed by this honorable Khan and my lord.
Which one is gone?
One the
Why do you say that without knowing the facts?
ନାଇଁ ତାଙ୍କ ନାଁରେ କେସ୍ କଣ କୌଣସି ଗୋଟେ କେସ୍ ବି ନାହିଁ ଗୋଟେ କେସ୍ ନାହିଁ ତାଙ୍କ ନାଁରେ
चलो adjourn it.
Adjournment or alternate?
बहुत time लगेगा. At 4:30 we can't. Yes. Next.
110.
110. Yes. 110. Yes.
Appearing on behalf of a successful government production,
Urgent. Yes. 111. 111.
My lord, I am there.
Yes.
Yeah.
11 vigilance.
I have filed this 482 seeking quashing of the registration of FIR and investigation.
It needs little hearing.
It needs hearing. One thing your lordship may see. When the matter was last listed, my learned friend submitted that investigation is over. Charge sheet has been filed. That's why I have annexed the order sheet.
Where is the charge sheet?
Your lordship may see the order sheet.
Yes.
At page 15, my lords may see.
Yes. Yes.
Now, your lordship may look at page 20 of the IA, my lords. IA 979 of 2024.
10?
IA number 979 of
Yes.
2024.
Page
Page 20. 20.
20. Okay.
Order dated 28/2/2023. Record is put up on receipt of charge sheet number such and such under 13(2) read with 13(1)B and 12 against accused Biraj Mohan, namely Biraj Mohan, ex-assistant conservator of forests, and his wife Shivani Mahanti, wife of Biraj Mohan. Keeping investigation open under 173(8) CRP. Then your lordship may see what the PO writes. Put up on 31/3/2023, awaiting sanction order, if any, against the accused. So the investigation is not complete. They have not obtained a sanction under 19, but a charge sheet has been filed. And the matter is awaiting receipt of sanction, as though the PO has nothing else to do but wait for years awaiting receipt
What is
of
this for?
sanction.
Have you
Your
got
lordship may
taken
call
now?
it some other way.
Thing is that when the FIR was registered, immediately soon after registration of FIR in a DA case, he filed a petition for quashing of the FIR. Your lordship kindly see the
That's right. But now
quashing of the FIR. And this honorable court, with all respect, insisted to complete the investigation.
No.
And we completed the investigation from our side and moved for sanction. And sanction discussion has been made. And we filed the charge sheet and showing that awaiting sanction on keeping investigation.
Now what is this phase? Sanction you got?
No, we have not got the sanction order. We are awaiting for the sanction order. And without sanction, cognizance cannot be taken. That is the law. And we have some, if sanction will not come or sanction will be declined, will not, pending sanction is not, but on that count, proceeding cannot be quashed. That is the recent judgment. This is the recent judgment of the Honorable Apex Court.
No.
On that count, no man, this is the law.
This is not the law at all. Either my learned friend hasn't read the law, or my learned friend is.
I do not know whether
something
I am not well of law, but Supreme Court is aware of law. Your lordship kindly see the law decided recently.
No, the court go by the submission.
No, this type of assertion, not the law. Your lordship kindly see.
Anyway, you tell me the exact position by next day. Today it needs to be heard.
That is separate.
Adjourn, huh? Adjourn.
My lord, keep it to any day next week.
Next week.
Next week, same position will be covered.
No,
unless sanction will.
Your lordship has to hear on merits as to whether such a charge sheet, incomplete charge sheet, without a sanction, that satisfies the criterion which the Apex Court has laid down. My learned friend
no court shall take cognizance without.
Exactly.
That is not the law. Law was pending sanction, whether proceeding can be quashed, pending sanction. My lord, the Honorable Apex Court has said no. 15th has
कोड़िए में 16 की 17
किंतु तांकर prayer, they cannot go beyond the prayer.
I am not going beyond the prayer.
Prayer is
112.
May appeal, sir. I am for the OP2, my lord. I am in the VC, my lord.
Yes, what do you want?
Pray for 1 week.
Adjourn. Yes.
Interim order to continue.
Interim order to continue.
113. 113 council association.
13 कौन है बात? 22.
Adjournment on behalf of
113, I am for the OP number.
Interim order. This matter is going on since
The domestic violence proceeding is stayed by this honorable court.
Why this is pending for such a long time?
next week, man.
Quashing order, cognizance quashing.
GR quashing, one is GR quashing, and the with matter is quashing of the DB proceeding.
Next week on.
And the DB proceeding has been stayed.
Next week, top.
Interim order.
Interim order is only creating problem here.
Last week.
That is the reason it is pending for such a long time. Otherwise, it would have been over by now. Thought interim order. Interim order will continue. It is made clear that no further adjournment shall be given in this matter. Yes.
115.
115
in person, my lord. In this case, I am challenging. One of the cognizance order taken by the STM Attagod.
Where is, you have not filed charge sheet, you have not filed anything except FIR.
FIR copy, yes, ma'am.
And you are not, are you appearing in person?
Yes, ma'am. In person, ma'am.
Where is the charge sheet?
I am not filing charge sheet. I am only filed the FIR copy and
You are challenging the cognizance order, sir. You need to file everything.
No, I have not filed the cognizance order. Only I have filed the FIR copy and challenging the FIR also, my lord.
Investigation is still on, or then, according to you?
The investigation already closed, my lord.
Then?
Yes,
cognizance is taken.
Kindly give me time to file the cognizance order.
At least you filed something.
No, before this, it is the 2022 matter, my lord.
22 matter, I don't know what is happening in this case. Why it is pending for such a long time? You filed it, you filed this petition when? You filed this petition
1/6/2022.
Better would be 31/5/2021. Better is, I'll dispose it up, giving you liberty to file a fresh one, if challenging the charge sheet. That is a better course for you. Don't waste your time.
Because this is the case that this case is pending against me.
Petition is filed on 31/5/2021. Quashing of the entire quashing of the FIR. FIR PS case number so on to so. The Land Counsel for the petitioner who is appearing in person seeks to withdraw the present petition with the liberty to file a fresh petition after the charge sheet is filed in the present case. With this liberty, the petition is disposed of. You file
Two cases.
Which one? Both the cases.
Wow, both the cases.
Both the cases. Liberty is granted. You file immediately once the charge sheet is.
Yes.
Okay?
116.
116, let it come some other, it's required thorough hearing.
Any day after 8th, your lordship, Mr. Palit is out of state.
And out of the ASU.
He'll give a date. He'll give it. 17.
117.
May I please? Here, my lord, I filed this application for quashing the entire proceeding initiated by the opposite party number 2, opposite party number 2, my lord. Here, my lord, my humble submission before your lordships that, my lord, the petition number 1 and opposite party number 2, both are husband and wife, my lord.
Have they settled?
My lord, the divorce has already been
Granted.
Granted, my lord.
So where they have settled then?
My lord.
You are not sure about what you are saying. Whether they have settled their dispute.
No.
Divorce is something different.
My lord, the matter, as per my humble submission before your lordships, my lord.
That the petition at the instance of opposite party number no.
But notice was issued, my lord.
Notice was issued.
My lord, and but they did not appear.
Service complete. Nobody appears.
My lord, service already.
Service complete.
Complete.
My lord.
Service on opposite party number, opposite parties are complete. None appears for them in the interest of justice. Please next week.
My
lord.
118.
May I please, your lordship?
Yes.
Quashing of criminal proceedings on the ground that the petitioner has already been married to the victim, my lord. Now they are living a happy marital life, and joint affidavit by the petitioner and the opposite party number 3 victim wife.
Bring them.
Pardon, my lord?
Bring them.
What I pray, my lord, they are at Dharamgad, my lord. So if your lordship will direct, they will appear at Dharamgad PS.
No. Watching here, what PS?
Like, any day, your lordship.
Bring them online or whatever.
Online at the Dharamgad PS, my lord.
You do it. Take them.
Unless your lordship will direct the Dharamgad PS will not allow them to.
POXO is there.
Yes, POXO is there, my lord. 17 years.
Especially GR, my lord, and my affidavit is on Landscape 2, my lord. Both the informant and the victim have got compromised.
Where are they?
Got married.
Where are they?
Issued. It's at this point in the list to happen notice.
Right on, the parties have settled that this is a FIR under section 376. POXO is not there. POXO is also there. You have implemented the victim.
Yes, ma'am.
Notice was issued or not?
No, ma'am.
Issue notice. Written resolution.
Proceeding is there, ma'am.
Issue. Bring them. The settled matter. You bring them. I am issuing notice. I am keeping it on 20th. 20th. Bring them. Yes.
120.
May I please, Your Lordship? This requires an extensive hearing, Your Lordship, because it deals with the quashing of FIR. The point of law is that, Your Lordship, there was a direction of the Supreme Court. All the cases should be transferred to the CBI court. Pursuant to that, CBI court himself also directed that all these state police cases should be to be transferred to the CBI court. Now, this is the tussle between the CBI and the state police, whether who has.
After Supreme Court says that it will be transferred, it will be transferred.
It has not been transferred, Your Lord. The state police is.
Counsel for CBI, Mr. Sartharia is unable to present today due to some health condition.
You tell me whether it is transferred to you or not.
Not yet, Your Lordship.
Transferred
Not
transferred
yet.
to the CBI.
Not yet, Your Lordship. Because the NBW has been issued in my name.
Milord, in the same point was raised, and this honorable division bench rejected the contention. Supreme Court confirmed. Again, second petition has been filed.
No, Your Lordship. This is wrong submission made by the
judgment
senior.
of this honorable court at page Milord.
That is 53 WPCRL 53
yes.
but they have not stated that. That is why I'm saying, Your Lordship, I'll prove they have not said what will be the effect of that order. That needs an extension here. I'll place the entire judgment, Your Lordship.
So,
Now,
this side of vacation, keep it.
and in the meantime, Your Lordship,
contention was
NBW has been issued by the state. Kindly allow me.
Yes, yes.
NBW has been issued, and in one of the co-accused case, this honorable court has stayed the proceeding. So I pray for that only.
I'll not stay the proceeding, but I will give you liberty to go and appear before the NBW. Who has issued NBW?
The lower court, Chhatrapur.
Milord, same contention was read before 4 benches earlier, and no interim order was passed.
No, Your Lordship, I have the interim order.
In this
He
case,
says something, you are saying something.
I have the
Your
interim
Lordship,
order.
message.
And that matter is connected, Your Lordship.
Have you given that declaration? How many cases?
Similarly placed, Your Lordship, 4029 CRLMC.
Where have you given that declaration that you have filed earlier cases?
I pardon, Your Lordship.
You have not given any declaration in the petition that you have already approached the court.
Court below?
No, in this court, how many cases are filed?
Milord, Your Lordship will find from the order sheet.
No, Your Lordship,
that
this
same
is.
contention was raised earlier before in 4 benches. No interim order. Your Lordship.
Where are those 4 petitions?
No,
Not 4 petition. In this case, earlier same contention was raised, but no interim order was passed.
I'll hear it. Sorry.
Your Lordship, I keep it to tomorrow if you are praying.
Not tomorrow. We'll give within this week or so. Yes. Next.
Okay.
122.
Much obliged.
But actually, what I pray, Your Lord, similarly situated.
No, but because see, there is no object. Otherwise, I would have stayed the NBW because he says something very serious.
I'm placing.
And I no.
The record is before Your Lordship.
This hour without knowing anything, I can't stay like it. It's very dangerous, I tell you. It's dangerous. Even you are not sure, and he says
I'm
something.
pretty
I'm
sure.
not sure.
I'm pretty sure, Your Lordship. That is why I'll
The
never.
problem is, I have to be sure.
That is true, Your Lord. That is why the record is with Your
I'll
Lordship.
examine it.
The record is with Your Lordship.
It is relating to whether, first of all, I'll have to see is it the same FIR where Arthur
Yes,
is accused?
yes,
And
Your
I can't
Lordship.
hear it
Okay.
because I appeared for one of the accused.
Then Your Lordship
If
may
the
transfer.
Arthur matter, then I can't.
It's a orthodox man.
Then I can't. Write down. Please the matters put before any other bench. Then I am not a party, subject to permission of approval of permission of Chief Justice. I appeared for one of the accused.
I'm so
Not
bad.
one of the accused, many accused.
I was not aware of this.
Yes.
122.
Lordship, went to the petitioner seeking a short adjournment.
Yes.
Since my senior is on-
Adjournment. Yes.
123.
123, may I please, my lords?
Yes.
My lord, this is an application under 482, my lord, for quashing of the criminal proceeding.
You are at this,
Lordship, may keep it
time
to-
you are threatening me showing this or something else.
My lord, a small point has to be
Small
decided.
point, such a big file.
My lord,
That
because
means
of
you don't have
the,
a case.
I have a good case, my lord.
So many petition.
My lord, just the EPC agreement makes it voluminous. else, my lord, there is,
See, then urgent.
my lord, may keep it to tomorrow so that
Not tomorrow, but he will give.
before vacation, my lord.
Before.
Hello, obliged.
Yes.
125.
Interim order to continue, my lord.
Entry mode to continue. 125.
Hello.
My lord, as per the last order dated 18/3/24, reply has not been received.
Yes.
They have not filed any reply.
Yes. You have taken time for filing reply. Also. Who is appearing? You are for petitioner.
Yes, my lord.
And none appears for opposite parties. And they have not, the opposite parties have also not filed any counter to the main petition. Urgent to also interim to continue.
Interim order
Yes. Next.
126.
126.
Covered by minor order. Is implement paragraph 5 man. Paragraph 5.
Last occasion I was instructed take the instruction from department. My lord, I have not been able to take the instruction since the department officer in the election duty. I see your permission on your website if you permit. So I can stay the judgment of one apex court which is in favor of our.
No, you seek instruction in any case. Next week. And give that judgment also on that day.
Bye.
Entry mode to continue.
127.
Lordship, to appear through virtual mode. Lordship, I'm appearing for the opposite part number 2.
Yes.
Yes. Your Lordship was pleased to grant us interim order, keeping in view the factual aspect of the case. No case is almost made out. So your Lordship may kindly keep it short there.
You are you going to file reply?
Yes, your Lordship. We'll file another 482 petition with regard to the counter case, your Lordship. There is a
whatever.
Yes, your Lordship.
And Counsel for the opposite party seeks time to file response to the petition. Urgent to so entry mode to continue.
Your Lordship.
Entry mode to continue.
No, keeping it to my lord short day.
So that this side of the weekend. Yes.
Obliged.
Yes.
128.
Praying for a short adjournment.
Here entry order is there and you have not same. Requisites not filed. Morning you mentioned it, I know. Requisites not filed. You have taken the interim order on when? Why have you not filed?
128
by way of this court has passed an interim order.
Appear already appear 128 appear
128 na?
Yes, 128
OP appear already appeared. So simply adjourn in the interest of
simple adjourn.
Entry mode to continue. Yes.
129.
It's there already there. Yes.
129.
Yes, 129.
Malaj, I appear for the petitioner through VC. Malaj, in this case, Malaj has already passed an detailed order in the other matter of Dhyan Foundation in the matter of 5310/23. And Malaj has in this matter has already passed some guidelines about the cattle. Malaj, the 8 cows matter. Malaj, may I request?
Keep it this side.
Yes,
yes. With it next week. So.
Yes, yes.
I have passed a judgment, but he is covered by that. Yes.
Malaj, this is covered by that. Malaj, may I only request to remand this matter to the trial court below before the magistrate court?
He is appearing. Are you appearing?
No. OP2.
Shall I remand it?
Yes, Malaj, because in the other matter also.
1 minute.
I'm sorry.
Because he is absent. Because
in absence, I can't do it. Put it this side.
Yes.
70.
Over. Yes, if I may please, Your Lordship, I'm extremely sorry, Your Lordship. In item number 110,
My lordship, interim order to continue, lordship.
There is an interim order, it will continue, don't worry.
Much.
If there is an interim order, you continue, unless I have order.
Already discussed.